You just have two prisoners transported today.
Well, three, but one of them was drug court.
Okay. Let's call Commonwealth of Kentucky versus Elizabeth Scott. Are you Elizabeth Scott?
Yes.
Good morning.
Morning.
You're at 21 CR 0056 for pretrial diversion, 22 CR 0086 for probation revocation, and 25 CR 0032 for pretrial conference. What does the Commonwealth have to say?
We have a plea on the remaining case, Your Honor, and Ms. Scott's agreed to stipulate revocation on the other two cases.
Okay, is that correct, Counselor?
Yes, yes, Your Honor.
Is this the felony plea?
Yes, Your Honor.
A motion's been tendered that says you wish to enter a plea today. Is that correct? Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given? Same person that we just identified in the three cases that are on the docket here. Is your judgment impaired today in any way?
No.
Have you discussed these matters with your attorney and are you satisfied with his advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you and you believe you're fully informed about this case?
Yes.
You understand that you do not have to plead guilty. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea of guilty, I need to know that you understand those rights. I'm going to go over the rights now and then I'm going to ask if you understand them. You have a right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury. The right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. The right to call witnesses in your favor. Have a process issue to compel their attendance. You have a right to appeal this matter to higher court if you lose. And a right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand that in your guilty plea today, you give up those rights. Do you understand that? I may consider the Commonwealth's recommendation by me applying range of sentence provided by law prior to accepting any recommendation. I will order a pre-sentence investigation report to be done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you will have the right to withdraw your plea of guilty and proceed to trial. Do you understand that? Mr. Hunley, what is the Commonwealth's recommendation in this case?
Your Honor, upon a plea of guilty of possession of a controlled substance, first degree, second offense, the defendant shall receive a sentence of 1 year to serve. Commonwealth opposes probation and or shock probation. And this agreement is based on the fact that the defendant has agreed to stipulate to the revocation in Cumberland Circuit Court in case numbers 21 CR 0056 and 22 CR 0086. The defendant shall pay costs at the discretion of the court and agrees to have any and all drug paraphernalia and or contraband disposed of according to the laws of the Commonwealth of Kentucky.
Is that your understanding of Commonwealth's recommendation?
Yes.
Are you pleading guilty because you did commit the acts charged in the indictment? Do so your own free will, knowing your constitutional rights till your desire to proceed with your plea and allow the court to fix your punishment within the range of law.
Yes.
You understand after you gets guilty plea, future convictions could be used in felonies could be used to enhance any penalties in those cases.
Yes.
That's your signature on the document. And Mr. Hunley, is that 1 year on top of these others that she's, I noticed you don't say for a total of what
I think it's a total of 7.
total of 7, and she had a pretrial diversion revocation. So she's stipulating to that. So that will go over
Yes.
at some juncture and we will let her invoke the felony plea on that and then the probate, the thing she had on probation and then this new charge. Is that correct?
That's,
What are the court calls?
$190.
Considering the length of the sentence and the complexity of it, I'm gonna waive the $190 on the thing. And I guess we can schedule the sentencing to be on, is it October the 2nd? Is that correct? October the 2nd. Okay. Thank you very much. Commonwealth versus Thomas O'Donnell. Good morning. Okay, is there any particular, you are Thomas O'Donnell,
Yes, sir.
born 1961, last four digits of social security number 6773.
That's correct.
We're here on 22 CR 00103. The motions that are being made here, have all been made by the defendant, except you have a motion.
I have two motions, Your Honor.
Okay. Do counsel for your side, have any preference as to how we proceed on?
I'd let the defendant go first. but-
Okay, motion limit testimony is?
Judge, yeah, we could start with what we likely agree on, which is the motion.
Well, that won't take long.
The motion in limine to exclude drug-related evidence from coming in at trial. My understanding is the Commonwealth has no objection to that motion.
That's correct. There was some drugs found in Mr. O'Donnell's vehicle in California. There was another person driving it, so I don't think it's very relevant at all. So
Wasn't a crime in Kentucky. Anyway.
that's correct.
Okay, you submit an order on that. I'll grant that motion.
Thank you, Judge.
Now, that is, under a motion to exclude.
Yes, Your Honor.
Okay. What's your next motion?
The motion to limit testimony also, I think the Commonwealth is in agreement with, that
You need to
relates
speak
to.
up.
Well, I was, but there's been a new case rendered by the Kentucky Supreme Court. I've changed my position.
Okay, well, state your motion.
Your Honor, that motion relates to Detective BJ Burton not being allowed to testify as to the interpretation of geolocational cell phone
Yeah, I got
data.
you. Yeah.
He's not been listed as an expert by the Commonwealth and nothing has been produced in discovery indicating that he has been trained in such a way that he would be an expert. Commonwealth has listed someone from the FBI, two different people who will be their experts on the cell phone extractions and the geolocation. So our motion is that BJ Burton be excluded from testifying about the interpretation of that data because he is not an expert in that area.
What do you got to say, Mr. Stowe?
Your Honor, without getting too far in the weeds, according to Detective Burton, when they get these readouts from the phone company, it's kind of like looking at a phone record. So I would suggest that Mr. Burton's probably either an expert witness or a skilled witness in this area. And there's a new case that came out in Kentucky. It was rendered on by the Supreme Court on August 14th, Hollingsworth versus Commonwealth. It's to be published, but it hadn't been published yet. It's 2023 SC 0126-MR. And it's about a 30-page opinion that goes through all the geolocational data evidence and when somebody's an expert, when they're not, when they're a skilled witness. And based on my reading of that case, I didn't furnish a copy since it's about 30 pages long. And I didn't think we'd want us to take time to read it this morning. But I think I will go back and amend my notice of expert witnesses to include Detective Burton, furnish his qualifications. If they have an objection, then they can object. But I think he would qualify as an expert under that case.
Your Honor, I think that we've passed the deadline for expert disclosures and
But will we, if we have the trial in October, we have. If we don't have the trial in October, we haven't.
yes.
And they're all, I could still rule on this without it being disclosed as an expert. Since receiving your motion and reviewing it, I just don't see how this sort of evidence could be presented in a sequentially understandable way unless the lead detective was able to testify at least foundationally about what was done. And then at any time we could interrupt his testimony to bring an expert witness in and not have him to have a continuous testimonial sequence. You follow what I'm saying? In other words, he could say, we did this, and then we could stop and call the expert in, let them testify to that. After the expert testified subject to your cross-examination, then we could continue with the lead detective's testimony. I mean, we can work it out at the trial, is what I'm trying to say.
Yeah, I agree. It's not fatal one way or the other. I just think from an
Yeah.
economy standpoint, he
Yeah.
could probably
Yeah.
tie it all together.
Yeah, so we'll make it work. I understand that you don't want someone that's not an expert witness or hadn't been qualified yet as an expert witness testifying about technology. So we can accommodate that, and I'm sensitive to it. So I'm going to deny your motion at this time. And if at any time before the trial or during the trial, this becomes a problem, we'll readdress the issue after you've had an opportunity to review this new case, okay?
Yes.
What's your next motion?
Judge, our other motion was a motion to strike the aggravating circumstance noticed by the Commonwealth as facially unconstitutional based on its vagueness and overbreadth. So the motion detailed our arguments in terms of, well, an aggravator has to be clearly defined in an objective way, and it has to have some meaningful basis to separate a murder that warrants enhanced penalties from any other murder.
The enhancement on this was a murder for hire, what was it?
That's correct.
Yeah.
Yes, Judge,
And
and
so you don't think that that's been set out specifically, you know?
Judge, the issue is with the statute as a whole and our request for this court to find it unconstitutional. And the aggravator reads, the offender committed the offense of murder for himself, herself, or another, comma, for the purpose of receiving money or any other thing of monetary value, comma, or for other profit. So our issue is with the for other profit language, and that language being vague, because we know the legislature separated it from a kind of monetary benefit. So we're talking about some sort of non-financial benefit to the offender. And because it's not clearly defined, a juror could take any motive, purported motive argued by the Commonwealth in any case and find that that motive is equivalent to some
Well,
perceived.
wouldn't the instruction have to state the motive? I mean, you'd have to state in the instructions that certain findings that the jury would have to make to get an aggravator, and that would have to be set out in the instructions, it would appear to me. I don't think that, I looked at that statute and looked at your argument. I think there has to be some vagueness to accommodate all the various things that might be used as far as I understand why they took the monetary out, because you could have drugs, you could have sex, you could have a lot of various things that could be used to compensate someone. So, and I don't know how, but we'll address that at the trial. And if we have that issue at the trial, but I'm not going to rule that that's unconstitutional. I don't think it might be vague, but it might be vague by necessity. So I don't see that it reaches the point of being unconstitutional. The unconstitutional of a statute like this would have to do with whether or not you're given and your client is given appropriate notice of where the Commonwealth is and what they're going to prove, so that you may put up a defense to that, and whether or not after it's proceeded, the court could rule on a directed verdict motion to see if it goes to the jury. And then when it comes to the jury, I think that factually would be within their province to look at the evidence and determine whether this is compensation to the point where it would enhance to an aggravator. So I'm going to deny that motion. You preserved it for the record, okay?
I understand, Judge. Will there be a written opinion on
There
this?
can be, if you request one,
Yes, please.
we'll be glad to accommodate you on that.
Thank you.
I might have to use AI to do it, but okay, and what's your next motion?
Our other motion, Judge, I'm sorry, is another one I think that we're in agreement on, unless Mr. Stockton has changed his mind on the motion for separate sequential penalty phases. And we're requesting that we have the merits phase of the trial where the jury will decide guilt or innocence on the murder count, and then move into a second phase, which would be the aggravator phase, where the Commonwealth presents their evidence to support the aggravator, and we present our defense to that. The jury goes out, decides whether or not the aggravating circumstance has been found beyond a reasonable doubt. And then we move into whatever the appropriate sentencing phase
If there
is
is one.
after that. Yes.
Into the half-truth and sentencing portion of it is. You know, one of the first cases that I got reversed here, was, a trifurcation. I really felt like that trifurcation was the best, approach, but the Supreme Court says bifurcation. And do you have a case where there's been a trifurcation like you're requesting?
Your Honor, I don't have a case with me, but I think that there is no Kentucky law directly on point related to.
Well, I try to
aggravated-
follow the law that's on point, you know what I
Yes.
mean? And every time I deviate from that, I seem to have my knuckles smacked on the thing, which
Yes.
doesn't bother me. I've got tough hands. But here, I understand the problem, but that's always bothered me, you know, on the PFO situations, you know. And usually on a persistent felony offender bifurcation, it usually is to the advantage of the defendant, because I've seen some jury nullifications when they find out what the increased penalty is on the PFO, and they go probably contrary to what the proof is because they don't want to go to the penalty. You follow what I'm saying? Now, I don't really see if this is a murder for hire allegation, I don't see how you can make a presentation to the jury without including that in the initial guilt or innocent phase. So that evidence is going to be in front of them there. And then on the instructions, they have to make a specific finding, as I understand, on the return on the verdict. Isn't that correct?
Yes, Your Honor. But the
So I
reason-
don't see how you're prejudiced by wanting it into three phases. I don't, explain that to me.
We're asking that for the purpose of the jury being clear on what they're deciding and when, and also the proof being clear, because in this case, with this particular aggravator, the profit part of it doesn't actually have to come in to show whether the Commonwealth's proof related to the murder. The for-profit, my understanding of what the Commonwealth will try to introduce is based on banking records.
I don't know any of that.
things like
I don't
that.
know any of that. You know, I'm not privy to that.
Yes, but so Mr. Stockton and I believe we're in agreement to doing it this way so that the jury knows exactly what they're deciding in the first phase, what they're deciding regarding the aggravator, and then our penalty phase meets whatever.
Well, I know what's gonna happen if I do this. If I enter the order, even if y'all agree, and there's a conviction on the thing, then y'all will step aside and someone from the appellate branch will come in and appeal that said that there's certain things that you cannot change by agreement, even by agreement of the parties. I know you don't have that intent now. I mean, you're trying to zealously represent your client. Are you in agreement with this?
Well, I prefer it. And just for the reason you said, I think it's an advantage to the prosecution when you do trifurcate it myself, but I don't want the court to do anything unlawful, because I knew the exact problem you were going to bring up, because if you trifurcate it, it's subject to maybe being overturned on appeal.
Yeah, I just don't see, I just think that there's certain limitations I have as a trial judge. And if you will get, I'll hold this in abeyance, I'll hold it open. And if you can give me some case law or a statutory authority for me to do this, then I'll reconsider that. But right now, I just don't have that, and I don't think it's in my province to do that, okay?
Yes, Judge, and I know that there is a Kentucky Supreme Court case that did not reverse the trifurcation issue based on a convicted felon on possession of a handgun charge. So as I said, there's not one directly on point related to aggravated circumstances.
Well,
in
now, you know,
Kentucky, but I will produce that.
you know, we deal with that handgun situation, convicted felon in a handgun situation pretty often. And usually they have separate trials on those issues to keep that from coming in the guilt phase of an associated crime. I don't
That's
know what
correct.
this case you're talking about
In
does.
this case, the judge did a trifurcation instead, where
Yeah.
they found whether or not the person was guilty of possession of the handgun, and then went into whether or not they were a convicted felon in a separate phase.
I'll be interested in seeing that. We might tell you if that's, well, they didn't overturn it, but did they, I guess they didn't address it or?
They do address it, and they didn't, I think that they said that separating it is the more common practice, but they did not reverse the
Yeah,
judge's
okay,
decision.
well, if you'll give us, if you'll forward us a citation on that case and then, and we'll bring it back up. Now, what's your next motion?
Your Honor, I think the last one we had was the order or the motion for our defense expert to attend the KCPC
I've got
evaluation.
no problem with that.
Yeah, and Mr. Stockton did not either, and we have an agreed order to
We're
tender.
good. That'll, just, you'll submit that later then, okay? Electronic. I think you're absolutely entitled to have your expert witness there.
And they also had the motion to file motions in Monroe County, I believe. Did you withdraw that or?
No, Judge, we filed a motion for leave to file additional motions in September. My I'm trying to figure out when the best rule day would be for the court.
We can schedule motions on days other than these days, if you want to. I mean, rather than jam you up against a trial date.
Right, Judge. I appreciate that.
So what I'll do is, we'll remove any restrictions you have. As long as you give proper notice to the Commonwealth and give them time to respond, we'll hear other motions, but I don't want, at some juncture, there's gonna be a cutoff on this thing. Because we have motion after motion after motion. I've heard all of them. I won't continue to let you have full hearing on it, but. Now you have motions. What do you?
I have two motions, Your Honor.
Is yeah, okay.
The first motion, I guess, is the motion for the evidentiary hearing, I think that's scheduled for September the 6th. I may have my date wrong. 8th, I'm sorry. It's for the defense counsel's alleged that certain privileged information was obtained from Mr. O'Donnell at the
Yeah.
jail. And that their privilege was violated. The way I read their motion is they're wanting basically the case dismissed because this happened. They're wanting the death penalty for the Commonwealth because of this. And so I have filed a motion, and there's case law, and I didn't bring it with me, but there's case law basically that the court can examine these materials and see if they are in fact privileged materials.
Have you had access to any of this material?
I have not, Your Honor. I've not seen it. I have not seen it. It brings up some interesting questions. One, was it privileged? I can write privileged on a roll of toilet paper, but that doesn't mean it contains privileged information. So I have no.
I wouldn't want to use it if you.
No,
if you
no,
were to
so
write that on it.
But that's the thing. I don't know if there's privileged information in there or not. I know that we.
I'm a little bit at a loss
Yeah,
for what's going on here. It was alluded to previously sometime, but
what happened was that Mr. O'Donnell was having difficulty at the Dare County Jail, and he was disciplined and moved to another cell. And
we dealt that a little bit last time.
But when he was moved, evidently some of the deputy jailers started looking through his materials, and it was allegedly marked confidential. I don't know, it probably was, but I've not seen it.
Yeah.
And one of the deputy jailers read through the information, and I don't know, there's not been one bit of proof taken yet. All we've got is hearsay and innuendo from everybody. But, so I don't know what was in there. But I think the first determination has to be made is whether there was any privileged material in there. And then did it prejudice Mr. O'Donnell in any way? If it was privileged information in there. And I don't see how the court can make a ruling on this case if the court cannot look at that notebook and see if there was any privileged information in it. And two, if Mr. Donald's convicted and gets life without parole or life in prison, this is going to go up on appeal. And how are you going to make a record unless that notebook is in the record? Some way, if it's under seal or not under seal.
Okay.
So I don't know how we can proceed without at least the court having possession of this.
And Judge, in our initial motion, we attached the envelope that the notebook was contained within, indicating that it contained confidential legal materials.
Well, I didn't see any of it. You just had the envelope.
Right, and
Yeah.
the notebook itself was marked. We received that notebook.
Okay,
and-
let me ask you something. Do you have any case law? I read your motion there, but what kind of case law do you have on the reasonable expectation of privacy that a prisoner has on documents that are in his or her cell? What would keep someone from having contraband hidden in a notebook or a box that had private on here, litigation matters imposed inside? Surely you must concede that a correctional institution has some authority to do reasonable searches of the property or the belongings of a defendant. Isn't that true?
They do, laid out by the administrative regulations. They can look through materials and not read them. They can look for obvious contraband. They cannot read the contents, and they have to do it in front of the individual, and none of that
Okay,
was
so
done here.
they violate that, then what's the remedy?
Judge, the hearing is not about the substance of the notebook. It's-
Okay, I understand, but if they violate that administrative regulation, should the remedy would be some action against the jailer who violated it to fire them? I mean, are you suggesting that all the case should be dismissed because a jailer on his or her own went and looked through somebody's private information?
Judge, at
I'm
this,
asking you to answer that question.
right, the hearing is to establish to what extent the violation.
Okay, let's say, I'm giving you a hypothetical situation. Go back to law school for a second, okay? Well, don't do that. I might get traumatized myself if I think that long ago. But let's say that I accept the fact that the person did invade, did read details that a person had in some sort of a notebook or something. What would be the remedy that you would request if that was found?
The remedy would likely be a request to strike the enhanced penalties. And what we need to establish.
What
during
does
the
that
hearing-
have to do with the enhanced penalties?
Because several jail employees went through this privileged material.
I'm not talking
then
about this case. I'm still in my hypothetical situation, okay?
It depends on what was communicated to the Commonwealth.
Okay, well,
and-
what if the Commonwealth says nothing was communicated? And then we're finished then on this, right?
And Judge, that's not our situation, because we believe this hearing will show that there was a chain of communication from the jail employees who accessed this privileged information all the way to the Commonwealth Attorney's Office, multiple prosecutors, in fact.
Well, okay, so they did do that. Now, number one, I'd have to find, let's say hypothetically they did do that. So number one, I'd have to find out that he had a privilege. That'd be the first thing, right? It was privileged information.
And Judge, I don't think there's a dispute as to.
Well, that's, can I interrupt you? You're assuming a lot of things and testifying about a lot of things that aren't in evidence.
That's it. Well, I'm giving her a
Right.
hypothetical.
Well, it is not privileged until it's established that there's
Well,
a privilege.
that's what I told her, Mr.
Yeah.
Stockton. I had to first determine, the first step is to
That's
determine
correct.
whether it's privileged.
Hence my motion.
Yeah, well, so once I determined it was privileged, okay, then I would have to see if his privilege was violated, if his expectation of privacy was violated, okay? And then I would have to determine if the violation was material in any way that would put him at a disadvantage, or the prosecution at some advantage. So there are multiple steps in this thing. But let's say it went your way on everything, just hypothetically. Okay, then what relief would you request then?
Judge, we would likely request a relief for the enhanced penalties notice to be struck based on the sequence of events.
What would that have to do with the enhanced penalties?
Judge, shortly after this violation occurred, that's when the enhanced penalties were noticed in this case.
And you think and you would have to prove that there was some correlation between this additional information and the enhanced penalty motion?
Judge,
So that's another step that you have to take, right?
Well, that's
Right, which-
factually incorrect because I gave notice, I think, of enhanced penalties earlier and it was withdrawn. And then I subsequently gave just on aggravating factor. I may be wrong, I may be confusing the murder cases. But if they're gonna testify, I'm gonna testify too. That has nothing to do with this notebook. We were getting ready for trial. I issued the enhanced penalty. Well, as I went in the
Well, I
trial.
mean, what I'm trying to go over is the steps in proof that would have to take and what result would be there. So I will have a hearing on this thing. Now, I am not comfortable. I am not comfortable myself doing an in-camera sort of review of this information, because that information, even if I did say it was, privileged, would be indelibly imprinted in my mind when I have to make decisions on whether to direct verdicts or things like that. And I don't know how I could view that sort of thing and not be prejudicial in some way. You understand what I'm saying?
I understand what you're saying, but how are you gonna establish that it's privileged and there was a communication? I don't know that they can even be privileged without a communication. And so you've got two
Well,
issues.
I'm not, I understand that.
Yeah,
Those are
from
step, well, that was step 1, 2, or 3, but I'm saying I'm not real big on doing that. I guess I could do it. But, you know, I forget things all the time, I guess, that aren't admissible. You know, I look at things that aren't admissible and instruct the jury, you shall not consider this or that, or give them an admonition. I guess I can give myself an admonition that if I see something in there, what are you shaking your head about?
Judge,
Go ahead. What?
Judge, I was just going to state that this in-camera review is unnecessary in this case, as Ms. Hines mentioned, as officers of the court, we have reviewed the materials and we are conveying to the court that they are privileged attorney-client communications. We cannot ethically turn those over while there is still privilege in place. Mr. O'Donnell has not waived that privilege and he has no intention of doing so. So I don't,
Well, if you're not willing to turn it over and they say they haven't received any of it, no harm, no foul.
That's right. Deny the motion. Let's move on.
Your Honor, that's factually inaccurate, which is why we're asking to have the evidentiary hearing.
But, we have a hearing scheduled, so we'll have a hearing, but I don't see, I don't see how your argument, you can't have it both ways. I mean, if there is confidential information that's damaging to your client and it's been received by the Commonwealth, you know, you'll have to prove that. But first you have to prove that he had a privilege and at some juncture. So we have someone that's read all of that. And are you telling the court, as officer of the court, that there are writings in those notebooks that have to do with privileged information that your client has shared with you,
Yes,
that shared with you?
yes.
I'm sorry, that's just not good enough for the Commonwealth.
Well, it's not, I didn't say it was good enough for me either. I'm just asking what they're saying, so.
And the problem,
You think, Mr. Stockton, although we hadn't gotten that far in your argument, you think that you should have an opportunity to review the document completely.
well, in the best case scenario, but I think the court should at least have the opportunity to determine whether or not there was a privilege and whether or not these witnesses are telling the truth. I can't even cross-examine the witnesses properly because I can't see the document. You know, this is the problem I've got. And the problem we've got is we've had 2 or 3 deputy jailers that looked at this. One of them looked at it extensively. And then it's kind of like an Andy Griffith episode. One deputy jailer tells one something, then they communicate with the Commonwealth attorney, and it has no factual basis when the state police goes out and interviews these deputy jailers. They say, no, I didn't say that. And that's in the reports. And so I don't know what's in the book. You know, I just know what they've said in the report. But I know there's a whole lot of hearsay floating out here.
Okay, well, we'll have a hearing and see where we go on it. What else you have?
Well, the other motion I've got is a motion to continue. I'm renewing that motion because I know the court was under the impression that Mr. O'Donnell's KCPC evaluation would be expedited. I think Ms. Zurcher's checked and my office has checked, and that's just not the case. There's no expedition on this.
Again, my belief that I have some influence in the Department of Corrections has been, or up KCPC, who's not run by the Department of Corrections. I'll get a Department of Corrections thing. I did call up there and informed y'all I was gonna call up there and talk, and I was told that it would be advanced. And it hasn't been. I haven't ever had any luck getting anything advanced up there, in person, or, you know, I really hate these Zoom evaluations that I just hate those things. I just don't see how they can do them appropriately without having an individual there and that sort of thing. And what would be your reason?
This is my reason. If they do get to the evaluation, Ms. Zurcher's, we've agreed that their expert has to be present. They're going to have to coordinate. Then there's going to have to be a report. And I just don't see, and this is not a standard murder case where I've got all my witnesses in the Commonwealth of Kentucky.
Yeah.
I've already did TUI letters to the United States Attorney's Office in Louisville on 11 different witnesses to get them approved to testify.
Would that be lab witness at Quantico?
Lab witnesses, FBI agents, hair analysis, fingerprint analysis, people of that nature. Now, I've also
So
got,
much for federalism,
now,
right?
I sent a letter to defense counsel, and it's their right. I asked for 10 items to be stipulated to as far as receipts and things across the country that'll have to be introduced at trial. I got back a response that they'd be willing to stipulate to one of them. So I'm gonna have to have at least 9 witnesses on those matters, and I've got about 15 witnesses that I'm gonna have to domesticate subpoenas on. And I'm gonna have to do that immediately.
Okay, I'm gonna continue this trial.
Okay,
Okay,
Can I
wait just a second. But one of the reasons I'm gonna continue it is for us to have this hearing. We're gonna have. And I will not delay this trial any longer than absolutely necessary. I keep a fairly open docket as far as scheduling things. I don't anticipate it being, if we get all these things wound up here 60 days later or something, I'm not talking about a year from now or 6 months from now or anything like that. But I just absolutely don't see, I don't want to use these, when I grant motions for the defendant, which I think are appropriate, I don't want to use them as a cudgel against the Commonwealth's ability to properly subpoena chain of custody sort of witnesses that are federal or maybe people located in other states or things like it. It's just not fair to the Commonwealth to do that. Once we get all these other things out of the way, then if at any time you think that the Commonwealth is not appropriately pursuing the domestication of these orders for, would that be the proper term?
that's correct. I have, Ms. Vanderpool, I think, is there 15? There's more. We've got them prepared. But the only reason I hadn't had the court to sign them was because this KCPC issue was hanging out over our head. But even if the trials continued, I'm going to go ahead and get the orders signed so I can be contacting these people. So when they get a date, maybe I can have a prosecutor that I can deal with in
When can your
California.
expert witness be available to sit down scheduling the KCPC?
Once they get the agreed order, Your Honor, they'll have his information and be available to schedule it as soon as possible. I don't know what his calendar is for the next month. But can I speak?
Well, yeah, you can say whatever you like.
I did speak with KCPC this week, Your Honor, and although they did indicate that it's not been put on the expedited track, the head of admissions told me that if there was an order to expedite it, it would be. And in that case, they would be able to get him to KCPC mid to late September.
Well, and then then we'd have a situation where we have a scheduling situation. Do you have any idea when your expert witness opens up?
I don't.
Your
Your
expert,
Honor.
not expert witness, your expert.
Yeah.
See, I just see that gets you sometime in September and he gets examined. You give him 10 or 15 days to get the report done. That would be more than it's usually a month before report's done. Then you got the trial. I just don't see how we can do that.
It's just too nebulous to prepare for.
Yeah, but I am mindful of your wanting to advance it. He's been in custody for quite a while. And one of my goals is to get him a speedy trial, even quicker than you could probably get anywhere. Because we're gonna move on this thing. Now, while we got everybody here, are there any other issues between the defense and the Commonwealth that we can address that might be stumbling blocks to us advance this thing?
There's outstanding discovery, Your Honor, but I've spoken to Mr. Stockton about it. I don't know if there's anything the court can do.
Well, I'll
file a
be
motion.
meeting with the FBI on September the 4th, their geolocational data expert, and hopefully we can get a report after that.
Okay, well, see, we're just not to the point where we can have a trial right now, so.
Yeah.
If you submit me an order continuing it, and then, we got 2 rule days in October. My goal would be on October the 23rd for us to again meet here and try to schedule a trial. If we can, it'd be better if you got your dates that your witnesses would be available. You think I need to schedule farther out and then?
Well, I'm thinking if it's continued, I think if we do it in January and February, that would be probably about as quick as we could do it.
Okay, well, let's have a status meeting here on October the 23rd to catch up to see where we are on scheduling for expert witnesses and all those sort of things. And I've usually found that it's not to the advantage of anyone to have trials of this magnitude around Thanksgiving or Christmas. you know, people have a tendency to rush things around Thanksgiving or Christmas, you know. Some people still, fewer people all the time celebrate these holidays, but,
Your Honor, could we submit an order for the court to expedite the KCPC evaluation to see if that would make a
I'd be
difference?
glad to
That's
do
fine.
that. It won't change the continuance, but it would help us. We expedite. I'm interested in see if they would expedite, because they already told me that.
Yeah.
You know,
That's what they're telling me too, Judge, but I think they need it in writing, so I say let's give it a try.
submit it and I'll put it, you put it in writing and I'll sign it. You'll all be happy.
Thank you. Thank
Okay, well, thank y'all very much. Okay, if y'all will clear this area over here, the grand jury's coming back. And Mr. Bell, you can sit there if you want to. I know you're very interested in seeing what's grand. Yeah. Okay, bring the grand jury. Judge Williams. I'm on the bench right now. Can I call you back at this number? Thank you. Pre-trial. Okay, bring the grand jury.
Sure.
All rise to the grand jury, please. Okay, everyone have a seat. Who's the fourth person in the grand jury? Mr. Foreman, have y'all completed your work?
Yes, sir.
9 or more of you agreed?
Yes.
With Mr. Bailiff, Sheriff, will you retrieve that for me and present it? You can have a seat, Mr. Foreman. Okay, well, I'm signing a document that will start the process to either get a summons or a warrant issued on the indictments returned. I want to remind you that it's very crucial that you keep confidential everything that you hear back in the grand jury room. We meet twice in October, but it doesn't add another time that you will serve. The scheduling was such. So the next time you'll come back, Mr. Judd, is that correct? October the 2nd? October the 2nd, okay? And then you'll come back in on October the 23rd, and you only have 2 more times before the end of the year that way, October the 2nd. So you are excused. All rise for the grand jury. Y'all can file out this way if you'd like, okay? Okay, Commonwealth versus Timothy Boggs. Everyone can have a seat. Commonwealth versus Timothy Boggs for sentence. Timothy Boggs.
Your Honor, he called me yesterday and said he had an obligation with the Indiana probation office, and he said he would fax some documents here to show that.
Oh, that'd be good. And after you fax them here, you can take it to him in the Adair County Jail, because I'm issuing a bench warrant for him to be held without bond.
Thank you, Your Honor.
Yeah. Stephen Bruce. Active warrant, NCIC. You might want to put Timothy Boggs at NCIC. I got a feeling that we won't be seeing him for a while. Julia Bush. Are you Julia Bush?
Yes,
Were you born in 1981?
yes,
Last four digits of your social security number are 9070.
yes, sir.
We're here on 25 CR 0053 for arraignment. Were you in district court on this case?
This is the first court I've been to.
Okay, so have you filled out an affidavit? You don't have an attorney with you, I see.
Yes, I filled one out this morning.
Do what?
I filled one out this morning.
Okay, she eligible? Okay, I'll put public advocacy, make sure I sign that in a minute. You have a right to remain silent. Your counsel is here. The grand jury of Cumberland County has returned an indictment charging you with traffic and controlled substance, first degree, first offense. You understand what that charge is?
Yes,
Okay. Counselor, do you acknowledge the identity of your client received indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions?
Yes, Your Honor.
Setting a reciprocal, I'm signing a reciprocal discovery order that requires the Commonwealth to provide your attorney information to help you prepare for your defense. When's your negotiation date, Mr. Tucker? Okay, you'll have to be here at September 19th at 9 a.m. for negotiation, and the next court appearance is October the 2nd at 9 a.m. and both of those are conditions of your bond, okay? Thank you. Thank you. Here you go. Christopher Catteray. Christopher, how do you pronounce your last name? Catteray, okay. You are Christopher Catteray. You were born in 1992. Last four digits, social security number is 6041. You're on 25 CR 0028 for a pretrial conference. What's the Commonwealth have to say?
That's pretrial version, I believe.
A motion, I've just been made aware of a motion that says you wish to enter plea today. Is that correct? Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given? Are you the same person that we just identified in 25 CR 0028? Is your judgment impaired today in any way?
No.
Have you discussed these charges with your attorney and are you satisfied with his advice?
Yes.
Have you viewed the evidence the Commonwealth has against you and you believe you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights and afforded to you under the Kentucky and United States Constitution. Before I can accept a plea of guilty, I need to know that you fully understand those rights. I'm going to go over them and I'm going to ask you to understand. You have a right not to testify against yourself. No one can make you say anything. Right to speedy trial of jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you. Right to reduce evidence, the right to call witnesses in your favor and have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose. Your right to require the Commonwealth to plead on a reasonable doubt that you're guilty of charges against you. You understand that by entering a plea of guilty today that you give up all these rights. You understand that? Now, I may consider the Commonwealth's recommendation, but I may find any range of sentence provided below. I don't have to accept the recommendation. In the event that I do not accept the recommendation, the Commonwealth decided to impose a harsher sentence. You have a right to withdraw your plea of guilty and proceed to trial. You understand that? I'm gonna ask some qualifying things since this is a diversion. Have you previously been diverted in the last 5 years? Have you had any felonies in the past 10 years? Are you currently on probation? You understand that if you fully complete the diversion agreement, the charges will be dismissed, pre-trial diverted, and your records can be expunged. You understand that?
Yes.
You understand that if you not fully complete the diversion, you will be brought back before the court and this court will schedule a sentencing hearing. You understand that? Okay. And at that time, you would be a convicted felon and that could be used against you in the future to enhance penalties and other felonies. You understand that? Okay, Mr. Commonwealth Attorney, what is the Commonwealth's recommendation?
Upon plea of guilty of wanton endangerment first degree, 3 counts, 3 separate counts. The defendant shall receive a sentence of 5 years on each count to run concurrently for a total of 5 years. He shall serve 90 days home in incarceration. The balance shall be pretrial diverted for 5 years with the diversion to be supervised. Upon a plea of guilty of operating a motor vehicle with alcohol concentrations above 0.08 or while under the influence of alcohol or other substances, the defendant shall pay a fine of $200. The defendant shall pay the fines and court costs at the discretion of the court. Defendant agrees to be assessed and follow any recommendations of the social service clinician. Defendant, of course, will receive credit for any time served.
Is that your understanding of the Commonwealth's recommendation?
Yes.
Are you pleading guilty because you didn't commit the acts charged in the indictment as amended? Are you doing so of your own free will? Now, previously, I explained to you that if you got revoked on the pretrial diversion, that could allow the use of the conviction of a felony because against you to enhance sentences. In addition to that, you pled guilty to DUI in this case. Do you understand that that's enhanceable too? If you get another DUI, that could be used against you, just like the persistent felony offender charge could apply on the felon. You understand that?
Yes, sir.
Can you pleading guilty of your own free will? And your constitutional rights explain to us your desire to proceed and let the court fix your punishment. Is that your signature on the offer?
Yes.
What did the total court cost?
$880.
How much?
$880.
$880. And you need some time to pay that?
Yes.
You pay it at $50 a month. First payment will be due 30 days from today and 30 days thereafter until you pay it. I accept the agreement, sign the division order. You'll need to meet with the probation and parole officer there, okay?
They're done sending the legal paperwork, we're going to sign.
Hey,
We turned in the DUI paperwork on this.
we'll double check it, make sure. Linda Crabtree. Are you Linda Crabtree?
Yes, sir.
Good morning. Were you born in 1992?
Yes, sir.
Last four digits, social security number 6000.
Yes.
We're on 25 CR 0049. And it says that this is a rocket docket case, where you're going to be arraigned. Let me have the document. You have a copy of the information.
Not with me.
Oh, I need a copy.
There's the original.
Well, I need to hand you a copy of it. You acknowledge the identity of your client,
Yes,
and I'm going to hand you a copy of the information. Your client agreed to proceed by information, is that correct?
that is correct.
And is this going to be this is going to be a pretrial, a felony plea or pretrial verdict?
I believe it's for trial version.
No, this is the identity of your client receipt of the information,
Yes, sir.
way formal reading and arraignment.
Yes, sir.
Now, a motion has been tendered, ma'am, says you wish to enter a plea today, is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given? Are you the same person that was named in 25 CR 0049?
Yes, sir.
Is your judgment impaired today in any way?
Uh.
Is your judgment impaired in any way? You know what's going on here?
Yeah.
If you discuss this matter with your attorney and are you satisfied with his advice?
Yes, sir.
Have you used the evidence the Commonwealth has against you, but you're fully informed about your case? You understand that you do not have to enter a guilty plea today. You have certain rights in the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights.
Yes.
We'll go over them then. I'm going to ask you if you understand. You have a right not to testify against yourself. No one can make the same thing. Right to speak trial of a jury, right to be represented by counsel at your jury trial, right to confront and possibly examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charged against you. Understand that by entering a guilty plea today, you give up those rights. You understand that? I may consider Commonwealth's recommendation, but I may apply any range of sentence without below. I don't have to accept the recommendation. In the event they do not accept the recommendation, decide to impose a harsher sentence, you have a right to withdraw your plea and proceed to trial. Do you understand that?
Yes.
I'm gonna ask you some qualifying questions. Have you previously been diverted in the last 5 years? Have you previously been diverted in the last 5 years?
No.
Yeah. Have you had any felonies in the past 10 years?
Just, charges, back over 5 years ago.
She hasn't had any convictions in the last 5
No.
years, felony convictions.
I said in the last 10 years.
13 years, sorry.
Have any felony convictions in the last 10 years? Do what? Well, I mean, you're hesitating here. What's the deal?
I'm not 100% sure, Your Honor. She might have been charged and had something amended down in the last 10 years.
She's not had anything in Kentucky, so I didn't have an NCIC report on run out of state. So if she's had anything out of state, I wouldn't be aware of it. So. She
You
said,
understand if you fully complete the diversion, the charges will be dismissed pre-trial diverted. Do you understand
Yes.
that? Okay, if you do not complete the diversion program, you'll be brought back before the court will schedule a sentencing hearing. You'll be a convicted felon that can be used against you under persistent felony offender law. You understand that? Do you understand that?
Yes.
Okay, what's the Commonwealth's recommendation?
Your Honor, Ms. Crabtree would plead guilty to possession of a controlled substance, first degree. She'd receive a sentence of 2 years, pretrial diverted for 4 years supervised. She would enter and complete the Cumberland Specialty Court Program, receive credit for time served, obtain and maintain gainful employment. All evidence in this case be destroyed, and she would pay court costs at the discretion of the court.
Is that what you agreed to?
Yes, sir.
What is the court cost?
$160.
$160, okay. Are you pleading guilty because you didn't commit the acts charged in the
Yes,
indictment
sir.
as amended? Or the information rather is, you understand that, if knowing your constitutional rights, I want you to understand that it's still your, well, you tell me that it's still your desire to proceed with this plea of guilty on the charges and allow me to fix your punishment. Is that correct?
Yes, sir.
Is that your signature on the motion and offer?
Yes.
I'll accept the agreement, sign the order. You need some time to pay the $160.
I just,
Okay, I'll let you pay it $30 a month. First payment's due 30 days from today. Meet with the probation parole officer.
Okay.
Okay, it's 10 o'clock and I'm gonna quickly shift to Barron County. Let me do, Kentucky Correctional Complex first.
They are on.
I got Shelby County on there. Well, let's do Shelby County. Shelby County, I see you on there.
Thank you, Yana.
You just got one case. This is Commonwealth Kentucky versus Buddy Dyer. 21 CR 00135. Are you Buddy Dyer?
Yes, sir.
You born in 1987?
Yes, sir.
What digits is social security number 6887? This is a
Yes,
motion.
sir.
Go ahead. Let's see your attorneys.
Yeah, sure. Buddy is doing a lot better now. He's enrolled in a SAP program.
This is a motion for shock probation. What's he in on?
What's that?
What's the charge that he's in on?
Oh, he was revoked. He got kicked out of the drug court.
Yeah. It was a possession charge, correct?
Yes, you're, sorry.
Where you, Mr. Stockton, where y'all on this?
Your Honor, Mr. Dyer was in the Cumberland County Drug Court for quite a while. He did good for quite a while. And then he had some problems and went to rehab. And then after he got out of rehab, he kept testing positive. So they revoked him from drug court. He was revoked on this case. He's got a 10-year sentence, and the underlying charges was assault to a police officer, 2 counts. We amended it to 10 years when he entered his plea. He's eligible for parole next August. He served 11 months and 23 days, and he served out some 34. So that's where we are.
Yeah, and Your Honor, he's enrolled in SAP now. He has a child
Well,
on the
he's
way. I
been
know
in,
he
he's
wants.
been in drug court, he rehab, and all these other things, and he played on police officer.
And
And he had all these dirty,
he just wants another opportunity.
well, I
to
know
get
he
out and
wants
get
one, but
into- yeah.
what makes me think that, I don't have dire.
Yeah.
But, you know, I just think he would need to wait with him, so respectfully, I'm going to deny it. I mean, there's just so many kinds of the apple that you get. Congratulate you on trying to improve yourself. Do you do that? You can come back and finish that, okay? Thank you very much. Thank you. Y'all are excused. Thank you. Okay, I guess we have, is Barron County on there now? Is Eastern Kentucky Correctional Complex on? It's Grayson County Detention Center on. Marion County? Marion County? Okay. Adair County, you're on at 10:30. I'll come back to you. Is there any other correctional institution that's on there right now that needs to be heard? Okay, will somebody try to contact Barron County and Eastern Kentucky as well as Marion County? So we got Barron County, Eastern Kentucky Correctional Complex, and Marion County. We'll go back to the live docket here.
Your Honor, on Eastern Kentucky Correctional, that's where Mr. Bricker is housed. I've had a lot of difficulty getting in touch with anyone. Mr. Stockton and I have talked about that, and we had agreed to send him for another negotiation day and have him transported to try and help with that. I actually sent an order to Ms. Thompson just while I was sitting there.
You're gonna have him up on the 19th?
Yes, yes, Your Honor. Mr. Stockton and I have been working.
Okay,
very
well, I'll
hard.
sign it. I'll remove that from the docket and put it on the 19th.
I guess it had it on October 2nd.
Yes, that would be my plan.
And then, it'd be here on, you want him here on October the 2nd after that?
Okay, we can, Your Honor, yes.
Okay, let's put both those in order. Okay. Dixon Escalona, is that how you pronounce your name?
Yes, sir. Good morning, Judge.
Commonwealth Kentucky versus Dixon Escalona, 25 CR 0026.
Dennis Burke on behalf of Mr. Escalona, Judge.
Okay, sir, were you born in 1997?
Born in 1997. He was, we have an interpreter available, Judge.
No.
Okay. I'll acknowledge his identity.
Wait a second.
There is one about on the language line.
Okay. Get them on the line right now.
Yes.
I used to have a phone here. I don't, oh, there it is. Okay. Okay, all right. Are you private counsel or conflict counsel?
Private counsel, Judge.
So you'll be responsible for an interpreter for him.
Yes, sir. I communicated with the translator app.
Okay.
Speakers, but that's light up there. Interpreter, will you identify yourself?
Yes, my name is Leo, ID number 250478.
Okay, Leo, do you solemnly swear or affirm that you're qualified to be an interpreter by the administrative office of courts in the courts of the Commonwealth of Kentucky?
Yes,
Okay, I have before me Mr. Dixon Escalona, is that how you say it last name?
Yes, sir.
In 25 CR 0026, you're on the speakerphone and he can hear you.
may I introduce myself?
Yes,
Thank you. Sí, bueno, yo voy a ser el intérprete en la conversación.
Speak up.
Ok, está bien.
you need to speak up, sir.
Está
Tommy.
bien, lo
Sí,
entiendo.
hable un poco más fuerte, señor, para poder escucharlo.
Sí, lo escucho.
Yes.
We're here for the purpose of arraignment.
Muy bien, estamos aquí con el propósito de hacer la lectura de cargos.
The grand jury of Cumberland County, Kentucky
El
has,
gran jurado de Cumberland County de Kentucky
has charged you with selling or receiving a vehicle with identification number removed or altered.
Muy bien, se le está acusando de vender o recibir un vehículo con el número de VIN removido.
You understand what that charge is?
¿Entiende usted ese cargo?
Sí, lo entiendo.
Okay. Counselor, do you acknowledge the identity of your client, the receipt of the indictment, waive formal reading and arraignment, enter a plea of not guilty?
I do, Judge.
I schedule a negotiation day with the Commonwealth on September 19th, and the next court appearance is on October 2nd. And both of those are conditions of your client's bond.
Muy bien, en este caso agendamos lo que viene siendo la mesa de negociación para el día 19 de septiembre y la próxima fecha de corte para el día 2 de octubre. Estas dos son condiciones para lo que es la fianza de su cliente.
Yes, sir, Your Honor. And will that be at 9 a.m. on the 2nd of October?
9 a.m. on both days.
Yes, sir.
Okay. There's no complaint about the bond, so your client will remain free on the same bond.
Muy bien, no hay ninguna queja sobre la fianza, entonces su cliente mantendrá en libertad bajo esa fianza.
Now, do either one of the council need the interpreter any longer on this? Okay,
No, sir.
okay, thank you, Mr.
Thank you, Judge.
Thank you, Mr. Interpreter. You are excused.
Have a good day, Your Honor.
Thank you for your services. Have a great day.
We need an address on council up here, okay?
Yes. I can file a formal inquiry appearance if you'd like, Judge.
Well, that's not, just tell her it'd be good. Chad Faulkner. I've signed a reciprocal discovery order, council, so they'll send you the discovery.
Thank you, Judge.
You are Chad Faulkner. This is 24 CR 00011. Were you born in 1983? Last four digits, social security number 7024. Is that correct? It says it's a hardship license hearing. What do we have here? Are you applying for a hardship license? I don't really ever do these. What's the story here on these hardship?
He turned in all application, so he can go to work, and get the license. He has his affidavit to him.
Where are you working, Mr. Faulkner?
EMK.
What?
It's for commissioners registration.
Yeah, okay. Commonwealth have any objection to this?
No, you're not, as long as it's for work or DUI.
6:30 AM to 4 PM. To drive back and forth to work only. Is that correct? Is that correct?
Yes, sir.
Where's the order that goes with this? You feel this time of use, he's got it on the affidavit back and forth for work only. You need to go outside of Cumberland County. Your work is all in Cumberland County, right? Okay. We'll fill that in. You can get a copy of it later today sometime, okay?
Great.
Thank you very much. Thomas Hoff, or Huff, rather. Commonwealth versus Thomas Huff.
Your Honor, talked to Mr. Huff on Tuesday. We have a plea, and then I found out that Indiana would not let, his probation officer wouldn't let him come today, so he is not here.
That's not nice.
It's kind of coincidence that they were together in the same car when they were charged with crime, and now they both have the same excuse for not being there.
They're,
I just find that
Family
coincidence, yeah.
well, it's family relations, so
Well, they
Yeah.
can have a reunion in the Adair County Jail.
I understand, Your Honor.
Bitch warrant there. And they might still be there by Thanksgiving. They can enjoy the turkey there. Probably NCIC on him too. Billy Huddleston. Billy Huddleston.
It's a family play.
Are you Billy Huddleston?
Yes, sir.
You born in 1962?
Yes, sir.
That's 4 digits, social security number 3418.
Yes, sir.
We're here on 25 CR 0025 for a pretrial conference, Mr. Huddleston. What does the Commonwealth have to say?
What I've got today, where is it?
They have to look at courts, you know. It's a family.
My God.
Have a felony plea, Your Honor.
A motion's been tendered that says you wish to enter a plea today. Is that correct? A motion has been made to say that says you want to enter a plea today. Is that
Yeah.
correct? Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person, Mr. Huddleston, that we
Yes, sir.
just identified in 25 CR 0025? That's you, right? Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
Are you impaired today in any way? You know what's going on here.
Yes, sir.
Okay. Have you had an opportunity to review the evidence the Commonwealth has against you? You feel like you're fully informed?
Yes, sir.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution.
Yes, sir.
Before I can accept the plea, I need to know that you understand those rights. Now, I'm gonna go over the rights at the end. I'm gonna ask you if you understand them,
Yes,
okay?
sir.
You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury, right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence. The right to call witnesses in your favor and have process issued to compel their attendance, the right to appeal this matter to higher court if you lose. The right to require the Commonwealth to prove on a reasonable doubt that you're guilty of charge against you. Understand that by entering a guilty plea today, you give up those rights. You understand
sir.
that? Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept any recommendation. Prior to accepting any recommendation, I will await the pre-sentence investigation report from probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. What is the Commonwealth's recommendation?
Upon plea of guilty to possession of a controlled substance, first degree, the defendant shall receive a sentence of 3 years, probated 5 years, with the probation to be supervised. Defendant shall pay court costs at the discretion of the court. The defendant agrees to be assessed by a social service clinician and will follow any recommendations. The defendant shall maintain gainful employment or do 30 hours per week community service until employment is obtained. Agrees to have any drug paraphernalia and or contraband disposed of in accordance with the laws of the Commonwealth.
Is that your understanding of Commonwealth's recommendation? Yes. Are you pleading guilty because you did commit the acts in the indictment as amended?
Yes, sir.
Are you pleading guilty of your own free will?
Yes, sir.
You know, ignoring your constitutional rights, I've explained to you, is it your desire to give up those rights, enter a plea and allow the court to fix your punishment?
Yes, sir.
Okay, you understand that after entering a guilty plea here, any future convictions of felonies could be enhanced under persistent felony offender law. Is that your signature on the document? You order a pre-sentence investigation report. Schedule it back here on October the 2nd for sentencing, and you may stay released on your same bond. You need to talk to the probation and parole officer.
Thank you.
I need to take about a 4-minute break here if y'all excuse me. Stop record.
Yeah. I just didn't say yeah, you didn't I mean, it's past the, he's not, I mean, Steve had state proceedings for him, totally illegal. Well, I don't care if I had laid 5 years. I'll do it one way or the other. No, I'm serious, I really think I'm looking at it. That's exactly what they're doing, they raise their feet. We eliminate the star change. And how do you not make a record for the old lady? Absolutely. That's a good one. Basically, you know, yeah, I just changed my all the wording. The last one. He's the one that they don't write about it. And I have to like 9 and 3. Oh, I should. Better yet. So that's where I'm supposed to do. I kept driving. 8 of that. That's really speaks.
Okay, let's go back on the record. I think we have some of the jails on there now. Barron County, are you on? Barron County?
Yes, we are, Your Honor.
Okay, thank you very much. Commonwealth versus Jordan Hill. 20 CR 0044. Are you Jordan Hill?
Yes, I am.
Born in 1996.
Yes, Your Honor.
Passport is number 126. What's the Commonwealth say in this case?
Your Honor, it's my understanding that Mr. Hill had some type of probation violation and he's going to get treatment or go into drug court. His probation is getting ready to expire and we're asking that it be extended a year or two so he can complete his treatment. Not that I'll motion to vote.
Okay, Counselor, have you talked to Mr. Hill? Is he in agreement with extending it rather than have a revocation here?
I have not spoken with him, Your Honor.
Mr. Hill, do you have any objection to your probationary period being extended? So we'll submit an order on that extended. Thank you very much.
Thank you.
Do what? Okay, Robert Tabor. Commonwealth versus Robert Tabor. 25 CR 0055. Are you Robert Tabor?
Yes.
Were you born in 1987?
Yes.
Passport, so it's your social security number 3597. You're here, here for the purpose of arraignment. You have your, I'm gonna appoint the Office of Public Advocacy to the Public Defender's Office. Do you have a private attorney anywhere, Mr. Tabor?
No, I don't.
Okay, so they'll represent you. You have the right to remain silent here. The grand jury of Cumberland County has returned an indictment charging you with rape, first degree of vulnerable victim. You know what that charge is. I'm not asking you whether you did it or not, but you know what the charge is, correct? Okay. Mr. Bailiff, will you deliver that? Counselor, do you acknowledge the identity of the client received indictment? Waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Yeah, I am signing a reciprocal discovery order, sir, that will allow, Mr. Tabor, that allow your attorney to receive all the evidence they have prepared for your case. He'll be over to see you. We're gonna, are we ready for negotiation in this thing, Mr. Stockton, or do you think, is there forensic evidence or
I
anything?
would think probably in October, but if Mr. Rutherford wants one in September, we can have one, whatever you want to do.
I would like to have it in September.
Okay, let's schedule this at 9 AM on September 19th for negotiation. The next court date, 9 AM on October the 2nd. And you'll need to give a transport order to bring Mr. Tabor over here for the negotiation. Your attorney will be over. When are you gonna go over to see you?
Probably sometime next week.
Okay, well, he'll be over to see you and discuss the charges with Mr. Tabor, okay? Thank you very much. Barron County, thank you for your cooperation. Y'all are excused.
Thank you so much.
Wait, Bobby Garman. You have Bobby Garman over there?
Give me just a second, Your Honor.
Do what?
That's Sean Watkins, Barron County too.
Bobby Garman.
He's showing
I don't see him on the docket.
He's in Barron. I'm from. So there, I didn't. Well, okay, but you might want to check, make sure. I'll wait. I'm gonna make it go over dollars.
I'm bringing him right now, Your Honor.
Okay, thank you.
Here you go, Your Honor.
Thank you. Are you Bobby Garman?
Yes, sir.
You're on 25 CR 0051. Do you have an attorney?
Not right now, no.
So I'm gonna appoint the Office of Public Advocacy, and you'll need to sign out an affidavit to see if you're eligible for them, but I'm gonna appoint them for the purpose of arraignment right now. You're here on 25 CR 0051. You have a right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with theft by deception. You understand what that charge is?
Yes, sir.
Counselor, you acknowledge the identity of your client, receive the indictment, wait formal reading and arraignment, enter plea not guilty, reserving all pre-trial motions.
Yes, Your Honor.
Okay, are you represented by the Office of Public Advocacy in any other court right now, Mr. Garland?
Not right now, no.
Okay, do you have a private attorney?
Yeah, I do for another case, yes, sir.
I represent him in Metcalf County, Your Honor.
Yeah, well, that might be a problem. But we'll let him do an affidavit. Mr. Poindexter says he represents you in Metcalf County. So
I'm gonna, go ahead, sorry. I'm gonna, if I can ever get out, I'm gonna make it to where I can pay him for my other cases, but try to.
When that's gonna be, in this case, he's got it advanced. I'm gonna go ahead and appoint public advocacy here. You can make arrangements to get Mr. Poindexter between now and then and make your financial arrangements, but, you know, I'm not gonna, it's not gonna be, well, you let me out of jail and I'll hire a lawyer and then we'll do this. That doesn't work that way. So I'll set a negotiation day up for September 19th. And the next court date is October the 2nd. And you need to make your attorney arrangements by then, okay? So
Is his bond set at? It wasn't on the indictment. I just wanted to make.
it's rate first degree. What is bonds?
Okay.
With an ankle bracelet. Okay. I know.
All right, I just wanted to write that in for Mr. Rutherford.
Okay, thank you. Now, what about, do y'all have Sean Wadley over there at Barron County?
I'm in the state, Jesse City.
Okay, well, Barron County, y'all are excused. Thank you very much.
Thank you so much, Your Honor.
Marion County, are you on?
Yes, Your Honor.
Thank you very much. Commonwealth versus John Metz, 22 CR 00109. Are you John Metz?
Yes, sir.
You born in 1994?
Yes, sir.
Last four digits, social security number 8287. You're here on a motion for shock probation. Who filed it? Is Office of Public Advocacy involved in this?
I believe so, Your Honor. Here comes Mr. Rutherford. Or, well, it's all right. Never mind. That is not Mr. Rutherford.
Yeah, Mr. John Metz motion for shock probation.
Yes, sir.
Okay. Tell me about it.
Yeah, so John Metz he's doing better. He's enrolled in a portals program right now.
Give me the underlying charge and how long he's been in and that sort of thing.
Yeah, the initial charge was a possession charge, and then he was revoked for an assault charge, which was later amended down to disorderly conduct. He's been in there for, I think, around 4 months now. He had an opportunity for parole, but unfortunately he didn't make parole.
They flopped him.
Yeah.
Shocked him.
Your Honor, he had a possession charge 3 years. He's parole eligible March of 2026. He served 6 months and about 16 days. The problem we've got with Shock is that he absconded it twice during the time he was on probation. The last time was on the basis for revocation. So we just asked, I talked to Officer Garner, he might get MRS. He might not be in there till 26th possession charge. We just asked to let him meet the parole board, let them decide it.
I think it would be his advantage to try parole rather than probation. He could get it behind him quicker that way.
The only other thing I would just say with it, he still has a job right now. They're waiting for him. They're holding open.
Who would the job be with?
What's that?
The problem was he's absconded
Yeah.
twice. Okay, and what was the assault charge about?
I don't know, that was in the other county.
Yeah, I think it was a dispute, and when the county attorney looked at it, he thought it would be more likely would be a disorderly conduct, if anything.
We've not had so much problem with that. It's just not reported to Officer Garner. That's the problem.
He had an issue with his father having terminal cancer, and he said he had
Well, here's Mr. Garner, you think that you can manage him, or has he just been too difficult?
I don't need to say anybody's too difficult for me to supervise, but he's absconded twice and not really giving me much of an option to supervise him.
Okay, well, he'll meet the parole board then, okay? Thank you very much. Thank you, Marion County, for your cooperation. Y'all are excused. Okay, see.
Judge Easter thinking correctionals on there, that's the case of most of my previous.
Eastern Kentucky Correctionals on there.
Yes, they're on there now. They're on there, Mr. Rutherford.
EKCC,
Yes, Your Honor.
Hall Bricker.
Yes, sir.
We made an announcement earlier about the counselor. What,
Yes, Your Honor. We have, there's been some substantial movement in the case that Mr. Bricker's not aware of. So Mr. Stockton and I agreed to reset this for negotiation day, September the 19th. I have tendered a transportation order for that day, and then we'll have it that day and reset to October
the
2nd.
change, so he might be aware a little bit. You're gonna call him later in the day and inform him.
Well, I would actually ask to make sure he has the correct number, because I've been getting some calls on my direct line that I cannot answer. So they have, when they're calling from a facility, they have to call the collect number.
You got a pen there, sir?
Yes, sir. I have been trying to call the collect number, and this facility has blocked the numbers for some reason. And they're not allowing my calls to go through to the office.
Well,
That would explain the problem then.
Okay.
So I'll get with COT. The number that you'll call is 502-564-4910. And
Correct.
if you call that number tomorrow at 8 a.m., no matter where I am, the office will route it to me.
8 a.m. Eastern time?
Central time. Thank you for clarifying that. I forgot.
Okay, thank you very much. And Eastern Kentucky Correctional Complex, you may be excused.
Thank you, sir.
Yeah. Okay, Dare County, we're running a little late here on it. We'll be with you in just a second. Here, got a few live ones left here. Angel Kington. For sentencing, Angel Kington.
I'm not sure where she's at here. I'm gonna-
Issue a bench warrant. Yeah, I tell you what, we're approaching again, you know, when I first started, when people entered pleas, I allowed them to be released on bond, do the pre-sentence investigation report. They can get their things in order, but it appears that we've had at least 3 cases today, so we might have to start taking people back into custody when they enter pleas today. You know, I'm just gonna have to take a look at it if it continues to be a pattern. Deborah Polson. Commonwealth versus Deborah Polston. Are you Deborah Polston? You born in 1976. Last 4 digits, social security number 9887. Okay, you're here on the Rocket docket. Counselor, do you acknowledge the identity of your client
Yes, sir.
and receipt of the information?
Yes, sir.
And you ready to enter a plea?
Yes.
Is this gonna be a felony or a pre-trial diversion?
It's a diversion, yeah.
Okay. A motion has been tendered, ma'am, that says you wish to enter a guilty plea today. Is that correct?
No.
Are you currently under the influence of drugs or alcohol?
No.
It's plea freely and voluntarily given. Are you the same person who's got identified in 25 CR 0050? Is your judgment impaired today in any way?
No.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
No.
Have you viewed the evidence the Commonwealth has against you? You believe you're fully informed about your case? You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept that you're guilty, I need to know that you understand those rights. We'll go over them and then I'll ask you, okay? You have a right not to testify against yourself. No one can make you say anything. Right to speedy trial, but jury right to be represented by counsel at your trial. Right to confront and cross-examine all witnesses called to testify against you. Right to, you said, produce evidence. Right to call witnesses in your favor. Right to appeal this matter to a higher court if you lose. And right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charged against you. You understand that by entering a guilty plea today, you give up all those rights. I may consider the Commonwealth's recommendation, but it may apply to your range of sentence provided by law. I don't have to accept the recommendation. In the event I do not accept the recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea. I'm going to ask you some qualifying questions. Have you previously been diverted in the last 5 years? Have you had a pretrial diversion in the last 5 years?
No.
Have you had any felonies in the past 10 years? Have you had any felonies in the last 10 years?
I thought I had one. Then I was 5 years ago.
I can understand what
I
she
had
said.
one that said I was 5 years ago.
She's had a felony conviction in the last 5 or 10 years.
Yeah, I said I was 5 years ago.
I said 10 years.
No, I was in memory.
I can't understand what your client is saying. Has she had a felony conviction in the last 10 years?
She's,
I only had one. It's been over 5 years.
you know, she said that she had one, but it's been over 5 years. He's asking if
I'm
he had
asking
one.
10 years.
No.
Well, okay, look, take her away from the podium and explain the question.
Yeah, I would.
Let me talk to you for you later. What's the story? What he felt is less. Felony.
This is one that was.
Right, okay.
Okay, let's proceed here. You understand if you successfully complete the diversion agreement, the charges will be dismissed, pretrial diverted. You understand that? If you don't successfully complete it, you're brought back in front of me, could be guilty of a felony that could be used against you in the future. You understand that? Okay. What is the Commonwealth's recommendation?
Upon plead guilty to possession of a controlled substance, namely methamphetamine, the defendant shall receive a sentence of 2 years, pretrial diverted for 4 years with the diversion supervised. The defendant shall enter and complete the Cumberland County Specialty Program, shall receive credit for time served, shall obtain gainful employment or do a minimum of 30 hours a week, community service.
She disabled?
And agrees to have any and all evidence, in this case, according to the laws of the Commonwealth.
That's what you agreed to, ma'am? Is that what you agreed to? Okay. Are you pleading guilty because you did commit the acts charged in the indictment? You're doing so knowing your constitutional rights, explain to still your desire to enter this plea and allow the court to fix your punishment. Is that right? Okay, is that your signature on the motion and offer? I'll accept the agreement, sign the division, or what's the court call? Y'all know about the burglary third. Is it a misdemeanor or felony? In Clinton County.
I don't know, Judge. Mr. Rutherford was
I believe
trying
that
to
was
show,
felony.
he thought it had been amended down, but, I wasn't able to find anything. Because I didn't.
Okay, well, I'll accept it as amended now. Okay, what's the court cost? $215. You need some time to pay the court costs. Pay $30 a month. First payments due 30 days from today. Meet with the probation parole officer and schedule a meeting with Mr. Murphy about the drug court, okay? Okay, I need to take about a 3-minute break here. Excuse me. Yeah, I think she's very important. About those, there's like things that you can use.
Jesse. We're posting this found against the February, the jury trial.
So she's.
Listen, she was charged February second, and the jury kind of didn't get the lesser included part of the coverage.
Still a detail.
It's still federal.
No, so I say, staff. With a fair negotiation. Let's read that. Back, did you hear that? Is she still able to?
I'll be back.
How does she find it on mistakes?
Mr. Taki, I want to come back up here.
This house is telling us, right?
Yeah, it's a problem.
I told her if we just had another negotiation, we'll go back to do it. Have a negotiation, set it back in October.
Yeah.
She want to go back and
Not yet, I'll tell you.
Thank you.
Here, I'm gonna tell you what, though. This is an example of what happened in the Rocky Dock.
Jim, I've not been measured, I've been
I
delegating.
know,
So,
so we'll just put her back on the docket. Let's put her on for negotiation day on the 19th. Let's go back on the record. Okay, while we took a short break and we were informed by some of our staff that Ms. Polson appears to have a jury verdict, felony conviction within the last 10 years. So I'm gonna withdraw my signature and agreement on that pretrial diversion and schedule her for negotiation day on September 19th and the next court date on October the 2nd. Counselor, you need to inform her of that.
I'll let her.
Okay, thank you very much. I'm gonna move back up to Adair County. We just got a few more cases here, but I don't want to hold the jail up there on mine. Commonwealth versus Denzel Burton. Commonwealth versus Denzel Burton. 22 CR 0058. Are you Denzel Burton?
Yes, sir.
Born in 1971.
Yes, sir.
Last four digits of social security 1609.
Yes.
You're on a probation revocation. What does the Commonwealth have to say?
Yeah, this is our second motion to revoke probation. Mr. Burton has a 10-year sentence on traffic and controlled substance first degree out of Cumberland County. And since July the 25th of 23, he's had 2 abscondings, 4 misdemeanor arrests, and just had a felony arrest after he absconded July the 30th. He got a felony arrest. I believe it was in Metcalfe County. I'll have to look. No, Allen County, I'm sorry.
What was the charge?
He's charged with, excuse me, he's charged with fleeing and evading police. I think I should have, Sergeant Del Rio on the line. He was being apprehended on a warrant from the absconding. He fled on foot and Officer Del Rio chased him and Officer Marr, injured his leg trying to chase him. And so I should have officer ready to go.
That was dismissed, Your Honor.
Yeah, my understanding was the felony charge. was
May have been
dismissed.
dismissed, but don't mean it didn't happen.
You want to hear him?
Yes, sir.
Okay, let's call you. Are your witnesses on there, Mr. Stockton?
thought he was supposed to be that, I'm saying.
Okay, well, let's pass over this for a second and see if y'all call your witnesses. Mr. Burton will bring.
We can still have a hearing on the abscond.
Well, I'd rather do it with your other witnesses,
Yeah.
okay? We'll do it today.
Okay.
And we'll come back to your case, Mr. Burton, okay? Alfred Casilius. Okay, we'll do the arraignment first. Your attorney's here. You have the right to remain silent, Mr. Are you Alfred Casilius? Born in 1955. The last 4 digits of your social security number are 5305.
Yes, sir.
Grand jury of Cumberland County has returned indictment charging you possession of a handgun by a convicted felon, possession of controlled substance, first degree possession of controlled substance, and second degree possession of drug paraphernalia, possession of controlled substance not in the original container, operating a motor vehicle under the influence, excessive windshield tinting, careless driving, failure to signal. You understand what those charges are?
Yes, sir.
You counselor, you acknowledge the identity of your client, received indictment, await formal reading and arraignment, enter plea of not guilty, reserving all pre-trial motion.
Yes, sir.
Now, I have a sentencing schedule here, Mr. Stockton. You think that we should hold back on this sentencing?
I would, Your Honor. I didn't realize when we entered the plea, I guess he had the other case in the pipe.
Okay, well, I think it would be to the advantage of the defendant and the Commonwealth to hold back this sentencing to think it and see if all these things might be resolved at the same time. Will you agree with that, Mr. Stockton?
I do, Your Honor.
Okay, so I'm gonna schedule a negotiation on September the 19th at 9 a.m. You'll need to do a transportation order. Next court appearance is October 6th, October 2nd. Okay, so your attorney will be up to see you.
Thank you.
All right.
Okay.
Thank you.
So back.
Jeremiah Fulton. Jeremiah Fulton. Are you Jeremiah Fulton?
Yes, sir.
Year of birth, 2006.
Yes, sir.
That's 4 digits, social security number 1424.
Yes, sir.
We're here on 25 CR 0015 on the probation revocation. What does the Commonwealth have to say?
Motion to revoke probation. He's got a 5-year sentence on theft by unlawful taking. He's had positive for meth, Suboxone, marijuana. He got out of pocket on July the 18th, 2025, and he was arrested in Clinton County without permission on August 5th, 2025. So I have Officer Garner testify if I need to.
Your Honor, he left when he finished up with his Tennessee charges. He left and he went to a halfway house. And I think there was some confusion on where his address was. I know that they did send notice to him to report, but I don't believe, he says he never received notice. I would just ask that they consider maybe sending him to a rehab.
It just amazes me. People think when they get put on probation, they don't have to report. I mean, what's the point of putting them on probation?
What's that been saying?
You want to hear him?
What's that been saying, so?
No, Your Honor.
You stipulate?
Yes.
Okay, well, I will revoke the probation and impose a sentence. And then he'd still be eligible maybe for a shock probation at some
Yes.
juncture. So if he's got some legitimate excuses, you can present them to in a motion for shock probation and present them to Commonwealth first, okay?
Okay, thank you.
Joshua Norris. Commonwealth, Joshua Norris, 24 CR 0077. Joshua Norris,
Yes, sir.
you born in 1989.
Yes, sir.
Last 4 digits, social security number 9019. We're here on a probation revocation. What does the Commonwealth have to say?
Your Honor, Mr. Norris has a 15-year sentence on theft, various charges. He was on probation. And he got in an incident on May the 16th in Adair County where he allegedly held a knife to someone. He admitted turning over a UTV, and I've got my witnesses present if I need to.
We'll need to hear it on this one, Your Honor.
Okay, call your first witness.
I'd call Patrick Campbell first.
Patrick Campbell, you raise your right hand. You swear the testimony you're about to give is the truth, whole truth, nothing but the truth.
I do.
You may proceed, Counselor.
Mr. Campbell, at some point in time in May of this year, were you supervising Mr. Norris or did you have a conversation with him?
I did. I was covering for Officer Garner while he was out, and I had a conversation with Mr. Norris on the May the 19th at the Adair County Jail.
Okay. Why did you talk to him on May the 19th at the Adair County Jail?
I was made aware that he was charged with assault 4th degree, assault 2nd, and terroristic threatening in 25F 50 in Adair County.
Okay. And what did you find out from your conversation with Mr. Norris?
So I went to the jail and spoke to Mr. Norris in regards to what had happened. I asked Mr. Norris for his version of the events. He stated that he had been drinking on May the 16th, the date that this incident took place. He started out drinking Michelob Ultra and then went to moonshine. Mr. Norris said that he turned over his father's UTV. I believe he said they were preparing for a wedding. He said upon doing that, he got into an altercation with his father. He did state that due to his intoxication, he normally probably wouldn't have reacted the way that he did. But the way he remembers the events, the altercation ensued. At some point, there was a group of people that kind of came around him. He pulled a knife in some form or fashion. He says he does not remember intentionally holding the knife to somebody's throat. However,
I did not. I did not hold a knife to anyone's throat.
Mr. Norris, try to stay quiet. We'll have an opportunity to ask questions of the
Not
witness.
the, I mean, get the story right.
Do we need to adjourn the hearing and do this in person or how we?
No, I'm fine.
Okay,
Okay.
So-
May I proceed?
yes, please.
Okay. Mr. Norris told me that he believes that there was a scratch or a cut on somebody's throat that must have happened when they were trying to get the knife away from him.
Okay, so Mr. Norris, was he allowed to consume alcoholic beverages while he was on probation?
No, sir.
Was he allowed to be intoxicated while he's on probation?
No, sir.
Was he allowed to brandish a knife while
Yes,
he was
no.
still on probation?
He is to have no deadly weapons.
Okay. So did he tell you how much he had consumed and what he consumed that day?
He signed an admission form, and I have sent a copy of that with Officer Garner. He signed this admission form on May the 19th to drinking beer, specifically Michelob Ultra and moonshine. He did not say the exact quantities, but he did acknowledge that he was intoxicated.
I have attached the admission sanction form to the motion to revoke probation. And it's signed May the 19th, 2025 by Josh Norris and PG, exactly, or PC. You signed that also, Mr. Cameron?
I did.
Your Honor, I ask that the items Commonwealth's exhibit.
Without objection, so ordered.
Did you take any other action in this case, Officer Cameron?
I'm not sure what you're asking.
Did you have any further involvement or take any other action in this case other than talking to Mr. Norris?
I believe I just put a detainer on him and requested revocation.
Okay, I have no further questions.
You want to inquire?
Yes, Your Honor. I just have a few questions for you, Mr. Campbell. Are you aware if Mr. Norris was indicted on any of these charges?
Yes, from what I've checked or from what I have seen, he was indicted. It looks like yesterday, and it looks like there's an active indictment warrant for him.
And then the other question I have, you said it was there were a group of people that surrounded Mr. Norris.
That's according to what he told me. Yes,
During this altercation he had with his father.
that's the way I understood what he told me. Yes.
That's all the questions I have.
Have nothing further from this witness.
The witness may be excused. Thank you. You got another witness?
Yes, Nick Barber, and I'm unsure if he's with the deputy sheriff or city police.
Is he online?
He is.
Nick?
Nick Barber, yes, Officer Barber, thank you.
Will you raise your right hand, officer? You swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I swear.
You may proceed.
Officer Barber, where are you employed?
I'm employed at the Dare County Sheriff's Office
And how long have you been employed there?
since April 2025,
Okay, how long have you been a police officer?
approximately 6 years.
Okay, did you answer a complaint involving Joshua Norris?
Yes.
And can you tell the judge what you did?
Received a complaint from dispatch, said that Joshua Norris had attempted to cut someone's throat. We got there on the scene. The father spoke with the father and several other witnesses on the scene that said that he had tried to cut this gentleman's neck. They fought the knife off of him, and then he took off with the knife in towards the woods. We went and looked for him in the woods at night. Never could find him. That was that night the bad storms came through. And next day I came out, his dad began calling dispatch when he get picked up. I didn't feel like at the time I could pick him up on that. There'd been so much time. So I went to the county attorney. She issued a warrant. I signed the warrant, and then state police picked him up.
Okay, did you interview any people involved in this incident?
Only briefly before we went looking for him. The next day, after got him arrested, I tried to speak with Mike Norris, as well as Tungate and a couple others, and they all refused to speak with me. They wouldn't give me a written statement or a recorded statement. They said that they didn't want him in more trouble.
Okay, did you get it when you talked to him the day before, though? Who told you that he'd held a knife to somebody's throat?
I think his name was Ethan Tungate and Mike Norris.
Okay, his father told you that?
Yes.
Okay. And so you got a warrant from the county attorney's office. Did you present this to the grand jury in Adair County?
I did yesterday.
Do you know if an indictment was returned?
I wasn't aware that if it was returned or not until you just now spoke of him having the warrant.
Okay. I don't think I have any questions from the officer. So you couldn't find him the night this happened?
I've never did find him then, and I've actually never even spoke with Mr. Norris.
Another officer arrested him and later, I guess, on the warrant that you had taken out.
Yes.
Okay, nothing further.
You don't have questions?
Well, I only have one question for him. And that's just, so the other parties involved, they didn't wish to provide a written statement. Is that correct?
That's correct. They refused to speak with me any further.
That's all the question.
Okay, this officer be
He
excused.
can't.
Officer, you may be excused.
I'm not gonna call any other witness.
Thank you, Your Honor.
I'm calling the witness either.
You wanna make your argument?
Yes, Your Honor. I mean, Mr. Norris was at the scene. He admitted to being drunk. He admitted to having a knife. He fled from the scene after the warrant was taken out, had to be arrested later. I'm asking, based on the seriousness of of these charges and these allegations, I believe he's a danger to the community, danger to himself, and that he be revoked.
And the only thing I would say, Your Honor, is, Mr. Norris admits that he consumed alcohol, which he shouldn't have been doing. There was an altercation
And moonshine.
in moonshine. But there was an
And
altercation,
he turned over a vehicle.
turned over.
And he got in a fight with his father.
He did,
And he pulled a knife on somebody.
when he was surrounded by people.
Oh,
I would just ask, if the other parties involved in this also, they want help for him, I think, more than they want any kind of long.
I don't know what the other parties want. They're not here.
I'm just basing it on what the testimony of the police officer.
Yeah.
So I would just ask for some type of long-term treatment or something, in lieu of revocation.
Well, I go back to the beginning of this case here. I remember when this plea was entered. It was a pretty controversial plea, actually, at the time. I believe that he got in a police vehicle.
With a gun.
Pardon?
With a gun.
Had guns in it and took off. And he got probated. I don't know whether I've ever seen that happen. Anybody
I think
steal
it's
a patrol
6
car
months or
with
something.
weapons and it get probated, But there was a lot of community support for him, including some of these same individuals at the time. So he got the break. For some reason, he can't conform. And here you got, except for a half an inch or something like that. The other thing can happen, if you come with a knife to a gunfight, you can end up dead too. Is you pull a knife on somebody, they'll shoot. So I'm gonna revoke the probation. Okay, thank you very much. Karen Spears. Karen Spears. Are you Karen Spears?
Yes, sir.
Born in 1974?
Yes, sir.
Last four digits of social security number 9237?
Yes, sir.
We're on 21 CR 00122 pretrial diversion revocation. What's the Commonwealth have to say?
She is the one that was put off from last month and was supposed to go on the specialty program. My understanding is she voted in this one.
Okay, well, Karen, they say you were voted in to the specialty, to the drug court this morning, so we'll schedule some kind of arrangement for her orientation.
Yes.
And so we'll have to enter an order releasing her on the day of the orientation, correct?
I guess Ms. Thompson can just contact Mr. Murphy when he wants to orient.
I was assessed here in Adair County and I was supposed to have reported to Adair County Drug Court on the 15th of August.
That's not the way it works, Ms. Spears. They have to get you transferred, so you'll need to deal with Mr. Murphy, and maybe we can get you transferred.
Yeah, they're gonna transfer the drug court down here, so we'll do it just as soon as possible, okay?
All right.
Good, thank you very much. Tiffany Stilts.
Oh, God, I'm going to be attention.
Tiffany Stilts.
Good morning, Judge.
Morning. This
How you
is
doing?
25 CR 0029. You are Tiffany Stilts, correct?
Yes, sir.
Born in 1988.
Yes, sir.
Just 4 digits of your social security, 4351. We used to
Sir.
left a little bit, Miss Stilts, just to your left. Okay, that's good. What does the Commonwealth have to say on this probation revocation?
Your Honor, she's got a 12-month sentence on fleeing and evading second, a misdemeanor. She absconded while on probation. According to Officer Garner, she basically refuses to report or be supervised.
You stipulate.
There's a stipulation on that and we'll revoke the probation. And that way she just got a year, right? So she'll be out pretty soon. Okay, thank you, Ms. Stills. Silas Tabor.
Seriously, I've got one need to go back.
Are you Silas Tabor?
Yes,
Morning. Were you born in 1976?
yes,
Last 4 digits, social security number 6042. You're here
yes.
for the purpose of, arraignment. Your attorney is here. And you have a right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with sexual abuse first degree vulnerable victim. You know what the charge is. I'm not asking you where you did it or not, but you know what the charge is, correct?
It's used the restroom.
You know what the charge is, Mr. Tabor? I'm not asking you.
Yes, but I didn't do it.
Wait, don't say anything. You know, it can be used against you. I'm just asking you if you know what the charge is. You're gonna enter a plea and not go. Counselor, Mr. Bailiff, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, and enter a plea of not guilty
Yes, Your Honor.
on behalf of Mr. Tabor.
Yes, sir.
I will schedule a negotiation there. Are y'all ready for negotiation or do you have a forensic? Any forensic evidence here?
I don't think so, Your Honor.
Okay, we have a negotiation day at 9 a.m. on September 19th. You need to do a transportation order
Mhm.
and then the next court date is on October the 2nd. And I'm signing a reciprocal discovery order, sir, that will require the Commonwealth to provide your attorney all the proof that they have. Okay, and your attorney will be up to see you, okay?
Yes, Silas, I don't know if you can hear me, okay, but Samantha Costello, who represents you in Adair, I'm gonna represent you on this one, okay, so I'll be up there to talk to you.
Okay, thank you. Shad Wadley, Sean Wadley.
It was used the restroom, but he's down.
Are you Sean Wadley?
Yes, sir.
Born in 1972, sir.
Excuse me, I didn't hear you.
You were born in 1972.
Yes, sir.
Your last 4 digits of your social security number 9513.
Yes, sir.
Hey, we're here on 24 CR 0031, a pretrial diversion revocation. What's the Commonwealth have to say?
Your Honor, this is a case, he has a 3-year sentence on possession. His probation was transferred to Georgia under the interstate compact. While he was in Georgia, they reported that he absconded and got a new felony arrest and asked that he be sent back up here for revocation. So that's what we filed a motion to revoke his pretrial diversion. I don't know, Mr. Bell, we made a request, he wanted an extra month, I think, to decide whether either they take him back or stipulate for the revocation. I don't know if you're still there or not.
Yeah, Judge, we had agreed during negotiation to see if they would take him back. I called, my understanding is that they have to go through interstate compact to do that. Right now, I believe the probation and parole officer is going to contact them and see if they'll take him back. If they don't, we're going to stipulate on a 90-day sanction, and I think we've got it worked out either way.
Stipulate as to revocation.
Yes, sir.
With maybe shot probation, certainly.
At the 90-day, right.
Well, let's don't get the cart before the horse. You're gonna see if they take him back.
Yes, sir.
If not, you're gonna stipulate. And then if he's revoked, then there'll be a recommendation of the Commonwealth, and I'll see if I accept that or not.
That's
Correct?
Well, that would be correct, Judge. I apologize.
Thank you.
Yes, sir.
Don't make me feel like a potted plant here.
No, Judge,
I'm involved somewhat. That's what they said in Watergate. Of course, Watergate was before your time. I
remember Watergate.
You had it in history class, I'm sure. Okay.
Yeah.
Okay, well, they'll be in contact, Mr. Wadley, with you, see if they'll take you back down there, okay, in Georgia.
Judge, could I tell him if he'd call my office, this afternoon, I'll explain everything.
You got Mr. Bell's number?
Yes, I do.
Okay, you call his office this afternoon. He said he'd give you a more detailed explanation of what's going on, okay?
Will do.
Okay,
Thank you, Judge.
Okay, we have Brandon Polston.
So Judge, I'm here on Brandon Polston.
Need to turn your camera on, I guess.
Oops.
Okay, what do we have on Brandon Polston?
This was my motion to set a jury trial date in his one remaining case.
Hey, what do you have, Mr. Stockton? You got any?
We'll just need to make sure the lab person.
Can you call him while we're here?
Yeah, we can. I'm trying to. This must have been an add-on or something. It wasn't on the circuit clerk's doc.
It wasn't.
That's all. So I didn't bring a file. So could you tell me which case number this is? I can't remember.
This is the 24 CR 50.
Where's the R50? So we don't have our file with us. We don't know who the lab person is.
Okay, this was a late add-on, and so the Commonwealth doesn't have their file or something. I'd suggest that you call the Commonwealth and we could schedule a jury trial without having another motion to do it. So can he call you this after Monday? No,
Monday or.
well, call tomorrow about 10 o'clock. Call the Commonwealth Attorney's office tomorrow about 10 o'clock. And then you get me on the line, we'll set a trial date, okay?
That sounds good, Judge. We'll be there.
Thank you. Did we had Denzel Burton still there?
Yes.
Did we have anybody else in Adair County besides Mr. Burton?
That should be it, Your Honor.
You want to call your first witness?
Well, I'm having difficult. I talked to Detective Weed about this Tuesday, and I thought he talked to Sergeant Del Rio and did a subpoena. And I looked at the file, and I don't see a subpoena in the file, and Miss Vanderpool can't get in touch with Detective Weed, so I don't know what's going on. I thought I had him lined up.
Okay, what's he been, is this what he being held on now, or? Is he
It
being
is,
held on
as far as I
something else?
know. I don't know of any other holding it.
This is a.
Well, let's reschedule this for October 2nd, okay?
Yes. If you want to lift the detainer and let him out, then I don't care, but it is.
I would schedule it for October 2nd. Okay? Your attorney will be in contact with you, sir, okay?
Thank you.
No, thank you. Okay, that, Adair County, y'all may be excused. Let's go back to the live docket here. Jeremy Spears. Commonwealth versus Jeremy Spears. Oh, man. You are Jeremy Spears?
Yes, sir.
Good morning. Were you born in 1978?
Yes,
Last four digits, social security number 3607.
yes, sir.
You're on 25 CR 0024 on a pretrial conference and a motion to suppress.
Your Honor, we have a plea.
Yeah.
It's a pre-trial version.
Be like in New York when I Sydney. Well, that's a different story. Okay, is this a diversion or a felony plea?
Diversion, Your Honor.
Motion's been tendered, sir, that says that you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in the indictment 25 CR 0024?
Yes.
Is your judgment impaired today in any way?
No, sir.
Have you discussed these charges with your attorney and are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence which Commonwealth has against you?
Yes, sir.
You believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to know that you fully understand those rights.
Yes, sir.
You have a right not to testify against yourself. No one can make you say anything. Your right to speed trial by jury or be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. The right to call witnesses in your favor. The right to appeal this matter to higher court if you lose. The right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand that by entering a guilty plea today, you have all those rights. You
Yes,
understand that? I may consider the Commonwealth's recommendation, but I have plenty range of sentence provided below. I don't have to accept the recommendation. In the event that I do not accept the recommendation, decide to impose a harsher sentence, you have a right to withdraw your plea. Now, I'm gonna ask you some questions reluctantly after my earlier experiences today, but have you previously been diverted in the last 5 years? No, sir. Have any felonies in the past 10 years? No, sir. Are you currently on probation? No, sir. You understand that if you do not successfully complete the diversion programs, that it probably will be brought back in front of me, and if I revoke it, you could be a convicted felon. Understand that? Yes. So if you do successfully complete the charge and be dismissed pre-trial diversion, you have your record expunged. You understand that? Yes. What's the Commonwealth's recommendation in this case, Mr. Chairman?
On a plea of guilty of possession of controlled substance first degree, namely methamphetamine, the defendant shall receive a sentence of 2 years pre-trial diverted for 4 years. The diversion is to be supervised. The defendant shall pay a fine of $500. The defendant shall pay fine and court costs at the discretion of the court and agrees that any drug paraphernalia and contraband be disposed of in accordance with the laws of the Commonwealth.
Is that what you agreed to, sir?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment as amended? Are you doing so of your own free will?
Yes,
You know your constitutional rights explained to you still your desire to proceed, enter a plea, allow the court to fix your punishment. Is that your signature on there? I'll accept the agreement, sign the diversion order. What the court cost in this case?
But with the fines, it's $690.
Now, what were the other things you found for insurance or something? What,
No, he had a bumper.
on what? Was it the DUI?
It was just part of the plea agreement, Your Honor.
Okay, so the usual $600 and what? $690. You need some time to pay that?
Yes.
Yeah, I'll let you pay it, $100 a month, first payment being done 30 days from today, okay? Yes. You need to meet with the probation and parole officer. Make the arrangements. Thank you very much. Andre Staten. Commonwealth versus Andre Staten. 25 CR 0042. You are Andre Staten?
Yes, sir.
You born in 1963?
Yes.
Last 4 digits, social security number 4710. You're here on a pretrial conference. What does the Commonwealth have to say?
Your Honor, we have a felony plea.
A motion been tendered that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in 25 CR 0042?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed these charges with your attorney? Are you satisfied with her advice?
Yes, sir.
Review the evidence the Commonwealth has against you. You believe you're fully informed about your case.
Yes, sir.
You understand that you do not have to enter a plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speedy trial, but jury right to be granted to the counsel to jury trial. Right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. Right to call witnesses to pay your process issue for attendance. You have a right to appeal this matter to a higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt the guilty charge against you. Understand that by entering a guilty plea, you give up all those charges. You understand that? You may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting your recommendation, I will await the pre-sentence investigation report from probation and parole. In the event I decide to impose a harsher sentence, you will have a right to withdraw your plea and proceed to trial. You understand that? What's the Commonwealth's recommendation, Mr. Allen?
On a plea of trafficking in a controlled substance first degree, the defendant shall receive a sentence of 3 years, shall serve 60 days home incarceration, and the balance of the sentence be probated for 5 years. The probation is to be supervised. Commonwealth does agree for home incarceration to begin on September 3rd of 2025. Defendant shall pay costs at the discretion of the court and agrees that any paraphernalia and contraband be disposed of according to the laws of the Commonwealth of Kentucky.
Is that what you agreed to?
Sir.
With one minor correction, Your Honor, because of Mr. Staten's condition of his legs, Mr. Stockton agreed to do it as a home incarceration as a non-ankle monitor, and we have signed that agreement on the plea.
That's correct.
Okay. You doing this of your own free will?
Yes, sir.
Okay, knowing your constitutional rights, still your desire to give up those rights, enter a plea of guilty, and allow the court to fix your punishment?
Yes, sir.
Okay, you understand that after any of this guilty plea, future convictions, you have to be enhanced under persistent felony offender law. Is that your signature on the document there?
Yes, sir.
Okay, I will accept the agreement and order a pre-sentence investigation report, schedule sentencing on October the 2nd. Now, what are the court costs of all of that?
His is $190.
Okay, we'll make a determination on that. It appears to me that he has a severe hardship there, and I might very well waive the court costs.
Thank
Okay.
you.
Okay. Kansas State. Commonwealth versus Kansas State, 25 CR 0041. Good morning. Are you Kansas State?
Yes.
Born in 1983, last four digits social security number 5643.
Yes.
We're here on the pretrial conference. What do you have?
Yes, we agree, Your Honor, the court will allow one more pretrial in this case. If we can't resolve it, we'll get a trial date.
Negotiation day on September the 19th at 9 a.m. The next court date's October 2nd. Both of them conditions your mind. Okay. Cody Stinson, I've got a note that Cody Stinson is in the hospital. Is that correct? That's correct. Okay.
I've heard all kinds of rumors about Mr. Stinson's health, whether he's comatose or everything, but evidently he's well enough that he can appear on Facebook and pose for a picture. And this is a case involving two young women that were sexually abused, and he's got a prison term. And I'm asking that he report to jail and let the Department of Corrections handle it at this point in time, if he's gonna flaunt being out of custody.
Your Honor, I think he does have a pretty severe medical issue, and I've provided some documents.
I'm just trying to get him sentenced.
Yeah.
Okay.
I'm not saying he doesn't have any help, but I've not seen him improve much for him.
Is he in jail? Is he in the hospital still?
Well, he was August the 23rd, looks like, at 11 o'clock.
Yes, I've spoke with his mother yesterday. He's still in the hospital, and I
Okay.
know that he has moments where he's pretty lucid.
Oh, okay. Well, here's the thing about it. I'm gonna schedule a sentencing in this thing on October the 2nd.
Judge,
Yeah.
the problem with that is that there hasn't been the sexual offender PSI report done because they couldn't locate Mr. Stinson. So in order for that to be done, a new order will have to be tendered, having that completed, so then that sets us back 60 more days.
So I guess we need to find out where he's at in the hospital so the probation and parole can go there and do the report and then get him sentenced. Because it looks to me like he's lucid enough to cooperate.
Is there any way probation and parole can have a sexual offender thing done by October the 2nd?
We don't do the sexual offender PSI, we do the regular PSI, Your Honor. There's a department in Frankfurt that deals with that directly. We don't have any direct relations with that.
My understanding is there's one person in the state.
And she contacted me and said that she had not been able to locate
Yeah.
Mr. Stinson, and that she would need a new order submitted with the correct sentencing date once.
Well, I would ask that the court enter an order for October 2nd, that I be provided with where he's at, so I can put that in the order. And maybe this can be expedited.
Yeah, let's just try it. We'll try it. I think that's a good suggestion.
So I guess on the record, can the Commonwealth find out where he's at in the hospital?
I can get that information to you.
And you get that to us by Monday, so I can get the order entered?
Yeah, I'll call as soon as I leave.
Okay,
How about that tomorrow?
tomorrow.
Well, I want you to tell your client that the moment he gets out of the hospital, he should immediately notify you. You notify the Commonwealth. I'll enter an order for where he's going, because he's going back to jail. He's going back to jail as soon as he gets out of hospital. And I would further advise you to tell your client that he's not helping his situation. I myself saw online where they had a fund me thing signed up to raise money for him or something like that. And now they have these pictures there. I mean, this is very, very difficult on victims and their families. And it flaunts situations. I don't know how sick he is. I know what problems we had to transport him in the middle of the night, all those sort of things, which I'm involved in as a judge, not just things that are here. It's not ex parte communication. It's part of my job to see if someone has to be transported out and admitted somewhere else. But I'm wearing thin on this sort of thing. And if we have to schedule a hearing in the hospital room in Jefferson County, wherever he is, I'll go up there and robe and sentence him there if I have to. But I don't want him as a condition of his bond. He's got a bond as a condition of his bond. I don't want him back on Facebook. I don't want anybody being on Facebook for him. I don't want him out gomming around and flaunting himself. And he is. We'll find some way to revoke him and put him in a hospital somewhere to keep him. Okay, thank you very much.
Thank you.
Dakota Vincent. It's a rocket docket case for Dakota Vincent.
So Mr. Vincent,
I don't see him either.
I guess she's back in Warren.
Issue a bench warrant without bond. Austin White. Are you Austin White? Good morning. You born in 1999, last four digits, social security number 8022. You're on 25 CR 0045. For the purpose of arraignment, you have a right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with 5 counts of theft by identity. You know what the charges are, correct? Mr. Bailiff? Counselor, you acknowledge the identity of Mr. White, the received indictment, waive formal reading, arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, sir.
Have a negotiation day at 9 a.m. on September 19th here. Next court appearance is October 2nd. There hasn't been any complaints about your bond. I'll continue your same bond. I'm signing a reciprocal discovery order here. Requires the Commonwealth to give you the evidence they have to help your attorney prepare for your defense. Okay? Thank you very much. Cody Willis for sentencing. This is the last case on the docket. We have something to skip over. Do what? Yeah. Good morning. Are you Cody Willis?
Yes, sir.
This is 25 CR 0040. Mr. Willis, were you born in 1989?
Yes, sir.
Last four digits, social security number 2394.
Yes.
You're here for the purpose of sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation parole?
Yes, sir.
Is it substantially correct? Counselor, is there any reason that this gentleman should not be sentenced?
No, Your Honor.
Upon a plea of guilty to traffic and controlled substance first degree, the defendant shall receive a sentence of 2 years. The sentence is to run consecutively with the Cumberland Circuit Court case 23 CR 0040, probated for 5 years. Probation is to be supervised. Commonwealth agrees this sentence will not revoke his probation based on this charge occurred on May the 11th, 2021. What's the court call? You need some time to pay that?
Yes.
Okay, you pay it at $40 a month. The first payment is due 30 days from today. They have the other employment requirements and destruction. You'll need to meet with probation and parole.
Thank you.
Thank you very much. Is there any other matter to come before the Cumberland Circuit Court Criminal Division? If not, we will stand in. Okay, let's do the show cause docket. Where's the show cause? We have a diversion completion docket. Minnie Joe Graham, does the Commonwealth have any complaint about the diversion completion?
No, not any authority, Your Honor. They can all be dismissed.
Charles Thomas Haynes.
Yeah, thing we dismissed very.
Okay, and, Ebony Kowalski.
She can be dismissed for.
Okay. And I'm gonna do a quick show cause docket here. Commonwealth versus Jerry Coria. Are you Jerry Coria?
Yes, sir.
You owe $220.
Yes, sir.
When can you make the payment?
I can make payment, next week again.
Okay. Can you pay $50 next week?
Yes, sir.
Okay, you pay $50 by next Friday or you'll be held in contempt. So I let him purge himself. I issue a judgment with 30 days in jail and he can purge himself by paying $50 for Friday of next week. Okay?
Yes, sir.
Okay, thank you.
Thank you.
Dewan Lynn Maxey owes $205. Is he in jail?
He's in the hospital, Your Honor.
In the hospital? Well, how long's it been since he's made a payment?
He paid, July 30th, Judge. It's just this.
Okay, well, I'm gonna allow him. He needs to pay $50 by next Friday. $50 for next Friday or have 30 days, okay? So anything else coming before the court?
I had Brett Davis.
See, paying them with this decision.
Yeah, the payment.
Okay, I just want to make sure I saw that big.
Okay, well, we go off the record then.
Yes.
It's wild. God, but they agree.
All rise, circuit court, Honorable Judge David Williams preside.
Thank you very much. Everybody have a seat. Oh. Child support docket. Box Smith versus Box Smith.
Judge, payments are coming in. We have a order in place, just asking that the court review that December the 18th.
Okay. Submit to order. Sites versus sites.
Paying well, same day we can do, please.
Okay. And Commonwealth and others versus Raisin.
Judge, if we could pass this one, there's a motion being filed to change venue. So I think we'll probably lose that one here pretty soon.
Okay.
Style.
Hate to lose my docket.
Orders have been e-filed or hard copies as well.
Okay, thank you very much.
I guess, yes, it is.
Yes, it's great. It's something that we don't need, but I could want this.
Well, Works better.
Okay, I'm ready to, we can take up some matters here. If I've got the Pulaski Circuit Court case, we can, supposed to come at 1:15. Excuse me just a second. Hello? Yes.
Yeah, please. Yes.
Let's send an agreed order. No, this, when's he gotta go to the hospital tomorrow?
School 7.
Not much. Bruce always said, let's go off the record. Call Megan back there and have her come out here and talk to you about that.
A final order of distribution that shows Dawn getting the remaining balance.
Okay, it looks like the parties are here on the Pulaski Circuit Court case. And I'll call it up. This is Pulaski Circuit Court Division 1 Civil Action 22 CI 00283. Head versus Sloan. Okay. Hello, hello, how are y'all today?
Good afternoon, Judge.
Hello.
my name is Jim Ridings.
I know you're Mr. Ridings. You can get behind the podium there and give Mr. Ridings a little room there. You got a motion to reconsider, a motion to alter, amend, or vacate.
Trying to give the lady a little room.
You're fine.
Go ahead.
I'm here on behalf of Karen Head. This court has previously entered a summary judgment against her. A motion today, as the court's probably well aware, is to reconsider and is to alter, amend, or vacate.
Okay, have you already filed a motion? Didn't we hear a motion to reconsider previously in this case?
We did not, because I was here and opposing counsel was here previously, but it was with respect to a handwritten docket entry, and the court declined to hear it that day, opting instead to wait for the entry of the formal typed order.
Okay.
That order was entered, and that's the one I'm here on today.
Okay. Go ahead. Let's just go down through the various reasons here. The issues of fact previously outlined here supported by evidence are sufficient justification to vacate, alter, or amend the entry of the summary judgment. Okay.
Yes, Your Honor. The issues of fact that we believe still exist, that we believe the entry of summary judgment is not proper because that entry, those findings were tantamount to actually a finding of fact by the court. Number one, my client has firmly testified without contradiction and has put into affidavit form the fact that she was coerced, she was forced, she was told by her husband to be, we go to the lawyer's office today, we sign it today, or I'm not going to go through with the marriage. She loved the man so much, she felt coerced into signing it, didn't even read it. My client asked to talk with the lawyer who had prepared it, not her lawyer, but Mr. Head's lawyer. And that lawyer wasn't there. She didn't have the opportunity to do that. She didn't have the opportunity to speak with her own attorney for signing it. So, in an effort to preserve the relationship, she went forward with it, but it was under coercion. Another reason.
Okay, I don't want you to argue all your things without seeing the case. Is that one reason right there?
Surely.
You want to respond to that, counsel?
Your Honor, the plaintiff characterized the facts that she was coerced, but the law does not support it. If you take her own admissions, first and foremost, they didn't have to get married at all, much less on that particular day. Number two, the prenuptial agreement had been percolating for, I think, weeks or months.
Let's just deal with the coercion portion of that's what he's arguing right now.
Right, so I think, and there's a case on point that we've cited to the court, it was the Aubrey case, that's not coercion or duress. She did not have to get married.
Yeah.
Period. She did not have to sign the prenuptial agreement.
I don't, respectfully, I just don't buy that agreement. I don't buy that. I've seen no case law on it. If you don't sign this, we're not gonna get married. Well, that'd be a good idea to tell him to take a hike. She loved him so much that she wanted to sign it anyway. I just don't see, that just doesn't hold it. So I'm gonna overrule reason number one. Let's go to reason number two. The fact that the plaintiff had the opportunity to consult with her family or to consult with an attorney of her choosing, or even consult with the attorney who prepared the document is justification for setting aside the summary judgment and justification for voiding a prenuptial agreement. Go ahead.
Yes, Your Honor. I have cited in the memorandum I prepared.
Yeah.
I have cited several cases, not just from Kentucky, but from sister jurisdictions, which declare that each party should be allowed time and opportunity to consult with his or her own attorney. Each party should be allowed that opportunity, or else the prenuptial agreement can be determined to be invalid.
It's voidable then.
It's voidable, it is,
Yeah.
but it's a jury issue as to whether it is voidable.
Whether she had enough time to consult with is a jury issue.
I believe it is, yes.
Yeah, what do you have to say about that?
I don't think that the facts support that. I don't think there's a material issue of fact on that. And it goes back to.
Speak up a little bit, please.
Yes, Your Honor, is to say the parties came to Judge Prather's office well in advance of the date that they married. And I think Ms. Head acknowledged that there was a supplemental agreement prepared that addressed her primary concern that had to do with the residence. So, in the document itself, which she signed, says, I've had full and fair opportunity to consult with the council of my choice. And she had, say, at least a period of weeks to do that. The facts show, and again, these are not controverted, the facts show that there was a supplement agreement entered into by the parties that addressed her primary concern. She signed it. She didn't have to.
I respectfully suggest, Your Honor, that she did not have weeks to do that. The final version of that document was in the lawyer's office. Mr. Head had apparently seen it, and my client had not seen that final version until the day she was forced to go to the office to sign it or not sign it.
Force, I mean, you talk about this force, I just don't accept the force on this thing. And the fact that there were changes that she was involved in, I just don't think there's a disputable fact, so I'll overrule you on that situation. Now, let's go to number 3. The fact that the judge of the court declined to recuse himself from the case is justification for reconsidering or altering, amending, or vacate the summary judgment if it is correct that the judge of the court had previously been involved in a practically identical set of facts involving a prenuptial agreement. What are you talking about?
Your Honor, I don't have the investigation done myself.
Well, why would you make an allegation like
Because my
that, that
client
acted
has-
like that I have been involved in some prenuptial agreement, which is absolutely false, it's spurious, it's contemptible to me.
My
Now,
client informed me of that.
well, your client, has very little credibility with me. I've watched your client for quite a while and throughout this thing, but here's the thing about it. It was brought up in the argument somewhere that she'd been involved in a similar prenuptial, not me. And when it was brought up in the argument, it really impacted me that she'd gone through other litigation about a prenuptial agreement, and now she comes back again and tries to set aside a prenuptial agreement with a respected jurist, and lawyer, and given this opportunity, I don't buy. And then she has you to make this allegation that I had been involved in a prenuptial agreement. I don't understand why you would even put that in a pleading if you hadn't done any investigation. I'm very disappointed that you would do that.
I said if, because I
Well,
was.
if, yeah. Yeah, the guy is a bigamist if it can be proved. The guy is a liar if it can be proved. He is this. I mean, I just don't go for that. And the reason the previous attorney, I really believe if you'd have been involved in this case from the beginning, this case might have progressed differently. But she was the one that got off the case. The previous attorney did, and asked me to recuse because she said I didn't like her or something. I don't know. You have any response to that?
Yeah, I would simply say, I mean, obviously, as a circuit court judge, you hear a lot of things, and you're in a position where cases are going to come before you that might have similar facts or similar legal principles. That doesn't mandate recusal.
It wasn't any case I knew about. It was the party. She'd been involved in a case like this, and we made here's the thing about it. If you get somebody that has had a prenuptial agreement that's been litigated, and they come back to you and they say, well, I did another prenuptial agreement, but I love this guy so much that I decided I just had to sign it that day I was forced to do it. There's no education in the second kick of a mule. So, I mean, that hurt her credibility with me, but it didn't even get to the point where it was a fact. I mean, so I'm disregarding that particular argument. Further memorandum will likely be tendered herein about what? What will a further memorandum?
I didn't have anything additional to add beyond that. I was hoping that I could find
The
something.
court appears to
additional.
has not adequately viewed the whole record. I've spent hours and hours on reading memorandum and hearing things and trying to force discovery. It was like pulling a wisdom tooth to get discovery done in this thing because the resistance and things. So I don't see how I could be more familiar with the record than I am. And the court did not give plaintiff's counsel an opportunity to be heard on his own renewed motion for summary judgment at the recent hearing held on April the 25th. Well, if I heard the evidence and wanted and was going to enter a summary judgment one way, I can't do two summary judgments. They'd be mutually exclusive. So I don't understand that argument. You got anything else you want to put on the record so you can take it up? You can take an opportunity right now.
Yes, Your Honor. The last point I would like to make is that Mr. Head himself agreed that after 10 years of marriage, he would put the house into my client's name, the house of land, and that just didn't happen.
Well, is that in the prenuptial agreement?
It was.
Okay.
Your Honor, what Mr. Head said is that he would either do a deed consistent with the supplemental agreement in the prenup or do a will. There is in fact evidence of record that he did a will. Bruce Orwin testified at some length by deposition on that. There's a unsigned copy of the will in the record. Unfortunately, the original signed will was never located, but he did do it.
What did the will, the unsigned will and the testimony that was testified had been executed?
Correct. And it was totally consistent with the prenup.
Do what?
It was totally consistent with the prenup. And again, Your Honor, I think this is a non-issue because my client's position has always been, we will honor the prenup. That's what our dad wanted. That's what he committed to do. And that's all covered by the supplemental agreement. So I think the whole argument is a red herring.
Is there any additional action by your clients that would be necessary to honor the prenup? What do you suggest still needs to be done?
Not to my knowledge, Your Honor.
At this point, Your Honor, my client has to ponder her option of filing an appeal to the status of the case as it is right now, or as it will possibly be after today's hearing.
Well, just let her file the appeal and we'll just take direction from the big minds in the Court of Appeals and the Supreme Court after they take a view of this. I don't know where they can get a real feel of this case unless they've lived through it like I have. So I wait for direction from the Court of Appeals or the Supreme Court, and we'll address it accordingly. You know, everybody's got a right to disagree with a sitting judge and appeal them, and I'll accept if I'm wrong, I'll accept it and we'll move on with it. Okay, thank y'all very much.
Your Honor, I prepared an order earlier today and e-filed it. I got a hard copy if you'd like me to provide that.
Well, if it's e-file, we'll take a look at it. Okay, thank y'all very much. Have a safe trip.
Thank you, Judge.
Okay, Kozłowski versus Kozłowski.
Good afternoon, Your Honor.
Yeah, it's been a wonderful day.
She says Kozłowski. I struggle with the name as well, so. Fair motion, Your Honor.
Yeah, I'll view it here. Let me see if I can find it.
Yeah.
Okay, this is about the deed, right?
Yes, we're holding $60,000. We'd like to pay him and get a deed.
What's the story?
Your Honor, my lawyer recused himself because
Move over behind it, so I can hear you.
my lawyer recused himself because I couldn't afford to pay him at the time. I have made other arrangements and I'd like to have somebody represent me for sure. I signed it over, but the problem is it's the only thing that I have leverage. I just don't trust the situation.
I don't understand what, you were supposed to do a deed of conveyance.
Yes, sir.
And you're not doing it now because it gives you leverage in this case.
Well, it's not that. It's
Well, that's what you said. Explain that to me.
okay, I asked for 5 or 6 things in the separation agreement. And I got one, I drove away in it. The second one, a couple of years later, is heavily damaged and everything else is up in the air, gone. There's been no give. I've supported the kids on my own for 5 years. And
Okay, well, here's the deal. If you believed that the agreement that you reached hadn't been complied with by your former wife, you could file a motion to compel her to comply. And you didn't do that.
I was unaware. I never.
Well, you didn't do that. I mean, now, Mr. Cross has got a motion for you to execute a deed. And you're telling me that you're not going to follow the court order. because you have leverage. Is that, did you hear him say that, Mr. Cross?
My interpretation, Your Honor.
I'm sorry that it came out that way, Your
Yeah,
Honor.
well, I will tell you, you're gonna sign the deed, okay? You have a copy of the deed here?
No, I don't, because I'm giving him so many
Now-
to sign and make that provision with my petition sign.
Okay, well, if you, I don't, is that the deed?
No, it's a word.
Yeah. I'll take a look at the order. Here's the deal. The proposed order says that you shall immediately and execute the deeds of conveyance. Okay.
Yeah, we're asking, give me your phone number, I'll arrange to swap money and these.
Here, I don't really like the way this order is written,
Okay,
because I mean,
I'll be happy to regret.
yeah, here's the thing about it. I'm gonna give him 10 days to sign the deeds. Okay. Now, in addition to that, after you sign the deed, I'm gonna leave the case open for you to get an attorney and come and file any motion that you have to see any portion of that agreement that this lady has not followed through with, so you can have a complete hearing on the thing. But if you don't sign that deed within 10 days, I'm gonna put you in jail.
I will, sir.
You understand what I'm saying?
Yes, sir.
So I'll contact my staff attorney about the exact wording of this a little later. We'll leave it here and you can contact. And we'll.
Your Honor, I believe what we will do is tender the money and the deed to the clerk's office, and he can cover and sign, pick up his money.
Have you got, when will you have the deed here? Okay. Where do you live, sir? Okay, well, you come here and sign the deed, bring the money, and the deed will be down there, okay?
Thank you.
Thank y'all very much, and be sure to get a lawyer, and if you've got any shortcomings and thing, I'm gonna give you a full hearing on it.
Thank you, sir.
Okay. Okay, the next case has been withdrawn, I guess. West Bend Mutual Insurance versus Fletcher Excavation, is that correct?
I need my calendar for November and December. November.
Pardon? Hello? Was there someone that was speaking on this? West Bend versus Fletcher? Mr. George, if you're trying to say something, you got your mic off. Maybe I got my mic off too.
Judge, no, I wasn't trying to talk on that case. I apologize, said something to my secretary.
Okay, no problem. Okay, LaCosta Smith Carver versus Brett Carver.
Judge, good afternoon. This is Chris Davenport. I'm on Zoom.
Okay.
This is our motion to get a new trial date. Your Honor may recall this was set for a trial with you last week. There was a motion to continue that trial filed by Mr. George just a few days prior.
Yeah.
I agreed to move it to allow for her deposition, which was conducted last week in the courthouse. And so we need to get a new date from Your Honor. From a timing standpoint, there remains some compliance with the discovery you've ordered that's not been fulfilled yet. So I know Your Honor is very quick with trial dates. I think that in all likelihood, I will need another probably 45 days to make sure we've got compliance with your discovery orders.
Come back here.
Can
Come back here on October the 23rd. And we'll schedule, on that date, we'll schedule a trial. Now, let's go over some, to make sure we're all on the same page here about what has not been complied with. So Mr. George will be able to know exactly what you're expecting. Did you list what has not been complied with, Mr.?
I will, Your Honor. The last order you entered included the requests that were made during his deposition on page 4. Of those that I do not yet have is a copy of a $100,000 note that he claims he owes to, I believe, his grandparents. Number 2 is proof of loan payments that he claims have been made by Sarah Turner, who's a lady he's familiar with. The third were ledger documents for his hunting endeavors. He claims he has maintained. And the most important, Your Honor, would be responsive to our interrogatories number 8 and 9 that were propounded in 2023, specifically bank account statements that would be, in his deposition, he told me he has been operating through his mother's bank accounts. And so we continue to ask for, and I believe Your Honor's order requires him to supplement those discovery responses to give full answers. That would include the accounts he's been banking in, although they might be under his mother's name. That is the most important of those outstanding items.
Well, Judge, as to the, I thought we had furnished everything. I know we had a big stack of bank records. And I told Jonathan as to his mother's, all he has to do is subpoena those from the bank. But it's up to you, Judge. If you want us to go ask his mother, that's fine. As to the note to his grandfather, we know he owes his grandfather. There may not be a note. It was a family matter. I know when his mother loaned him $206,000 to pay Bluegrass Stockyards off over in Clinton County. I don't know that he gave her a note, but we have her check where she loaned it, and we have his check where he paid Bluegrass. But I'll get him whatever I have access to. Some of this stuff he could have subpoenaed himself, but I don't want to make this hard. I don't want to be hard to get along with. I'll be more than glad to furnish what we're able to furnish.
And I don't either, Mr. George. I wrote Mr. Lano months ago and said, if you'll tell me the bank the mother has the accounts at and what the account numbers are, I would subpoena them.
All right, I'll get that for you. I'll have that first thing in the morning. I'll have Brett call up here and give us that information, and I'll send it to you tomorrow morning.
Okay, that takes care of number 4 as far as the mother's accounts. Now, what about this ledger, the hunting ledger? What are you talking about there?
Is that question posed to me, Your Honor?
Yeah.
In his deposition, he told me that he maintains a ledger that has his hunting clients, how much they've paid, how much they owe. And so I wasn't aware of that ledger till his deposition, so I requested a copy of it.
Judge, if I may, I don't mind giving what money he may have collected, but I can tell you straight up, she has harassed and called a lot of his clients and people that stay at the lodge. And I'm not under, unless you compel me to do it, I don't want to give her any names at all. She doesn't need that because we've had people complaining about her harassment, and she doesn't, what she needs to know, the bottom line is the dollars. And that's what this case is about, beside the infant child.
I respect what you're saying, but I do think that the ledgers ought to be made available to the council, and that they should not be published by anyone, and there should be a protective order entered with some teeth in it, that she should not contact anyone on that list or interfere with his ongoing business thing, and I mean it. So
yes, and Judge, I appreciate that, because I do want to remind you that there was some confidential information that came out of the criminal case that they were not supposed to let leave the office, and yet a television station and some newspaper, whatever, they end up with some of that information. So there'll have to be some real teeth in this.
Your Honor,
I'm disregarding that. That's neither here nor there. Now, this loan payment that you were talking about, the number 2 item, you mentioned some kind of loan payment.
Yeah, proof of loan payments that were made he claims by Sarah Turner. And again, this came out of his deposition, something I didn't know about.
Who is Miss Turner? I don't know who Miss Turner is.
Miss Turner was a friend of Mr. Carver's, and for a period of time at separation, and was also a business partner of his, as I understand.
Are you talking about a paramour, or what kind of friend?
That's correct.
Okay. And what kind of payments were these that were made allegedly in the deposition?
I believe they were payments on his behalf, as I recall.
Payments to who?
That's what I wanna know, you know.
Yeah, Your Honor, I'm sorry, I don't recall that. I looked back at those requests and what we had requested and what was ordered and what has not been produced, and I can't answer that question without going back into his
Here's
transcript.
what I'm gonna do on that. I need a little bit more detail on any loan payments that were made. And are you saying that he's wanting credit on, to offset some marital property because some loan payments were made by this friend of his on something? I mean, what? I don't understand.
The significance of that, Your Honor, if I can pull up the request real quick, I think I had it open. I think the significance of that is whether there has been, he's claiming that those payments were somehow reduced, an obligation of his. And if I recall correctly, what caused the question was I found it interesting he was getting checks from her and what he claims those checks were for.
So you want a list of loan payments that he says reduce some marital obligation.
I think that's right. But I'll tell you what I do, Your Honor. I don't want to go off.
Okay,
half
let's
information
go to
here.
the $100,000.
Yeah.
Now, Mr. Ford, you said there was a $100,000 loan.
He's claiming $100,000 loan debt to his grandparents. And I just asked for, if that's been codified, I want a copy of it.
I'll check and see if it has. Well, I have no reason not to give it to you. It's to our benefit to give it to you.
Okay, well, if you'll, Mr. Davenport, if you'll just kind of reduce something loosely to an order here, and then, and put in there that we'll come back here, on October the 23rd. And if we get to that point and we have some additional discovery problems before we close there, then y'all can appear by Zoom again on October 23rd. We'll resolve any remaining discovery problems and set a date. And at some juncture here, then we'll have to hone this case down exactly and have a hearing. I think it sounds like a 2 or 3 day trial, and I can schedule that pretty quickly. Your all's schedule will be more of a problem than mine because both of you will probably have a lot more going on in different places, but I will accommodate whatever you need to do that, and we'll get it done quickly, okay?
Hey, Judge, if I might, if he'll just send me an email to me on what he wants here, if Brett can be up here tomorrow morning, we'll go over it and I'll give him orders to go get it right away.
Okay, that'll be good, but I still want to order in the record.
Yes,
So
I'll draft that and I will send it to Mr. George Have-Seen.
I'm not saying Mr. Davenport would move the goal line on you, but you know, something might happen to Mr. Davenport, somebody else might have to take a case, so we need to memorialize my order.
Yes.
That'd be fine. And
Okay.
Brett, you be up here at 10 o'clock tomorrow.
I'll take a crack at the protective language I think you've proposed and include it in that order.
All right, now let me say this. I'm not going to be here very long tomorrow, so actually I wouldn't be here now if Jonathan wasn't sick, but
thank y'all very much. Y'all have a blessed.
Thank you. See you, Judge.
Thank you, Judge.
Gilbert versus Gilbert.
Good afternoon, Judge. This is our motion for contempt on Miss Candy Gilbert.
Where is Candy Gilbert?
She does not appear to be present today.
But you served, I noticed on the certificate of service, you served it on her by mailing it to 2411 Red Banks Road. Does she still reside there?
Yes, Judge, that is the former marital residence.
Yeah, I know it was, but I didn't know. And I read the motion. Who all lives at 2411?
It is currently just Miss Gilbert, is that correct? He says that she's been in and out of the residence, but it's solely her.
And she did a deed to him?
Yes, there was a
quitclaim
quitclaim
deed.
deed.
I got a quitclaim deed.
Yes.
Well, you know, when I read this thing and thought about it, well, I guess I could order her out of it, could order the sheriff to go down there. Would it be, since she's inappropriately staying there, should it be a forcible detainer action to take her out in district court? It sounds like
Judge, there was a forcible
county attorney's
detainer.
here. Would you like to get involved in this?
Judge, I've got plenty on my plate,
Yeah.
adding something. to it.
Okay, well, I was afraid that would be it. So, the way you are.
Much as I appreciate being involved.
Well, I just want you to be involved.
Well, Judge, there is a current forcible detainer in the district court. However, my opinion was a motion for contempt through the circuit court was the better avenue to proceed. with.
Easier attitude for sure. Easier approach. Does she have furniture in down there? You can talk to me. Does she have furniture?
She does, like, she's been coming in and
I
just
don't want anything else about it. Does she have furniture down there?
some, but
The answer to that would be yes.
yes.
Yes, okay. Well, the problem that you get into with these things, if you go moving somebody else's furniture or belongings, then there end up being a lot more valuable things that are missing than you could agree to on that occasion. I want to, you submit an order to have her to vacate the premises, take all of her belongings out of there, and to appear here, if she has not done that, to appear here on October the 2nd to show why she should not be held in contempt. Okay? And I would suggest you have the sheriff's office serve that on her, that order, okay? Rather than just mail it at that address, since she is periodically in and out of that, and other people also have access to the mailbox and things there, okay?
Yes, Judge.
Thank y'all very much.
Thank you.
Brewington versus Brewington.
Your Honor, I'm standing in for Mr. Burke. He's elsewhere.
Okay, this is a motion. Evidently, there was the youngest child. There was an agreement with the parties that the children could be homeschooled. And now the youngest child wants to go to public school. And no agreement can be reached as to what is the best interest of the child. Is that
That is
correct?
it in a nutshell, Your Honor, yes.
What do you have to say about that?
Judge, we're opposed to that because one, I mean, if he was that concerned, why is he just now bringing the motion after we've had months and months waiting for him to make his payment, and then once he does that. when we were just-
Maybe he felt guilty to say anything till he made his payment.
Perhaps the child
And-
already done.
And some of the things he's alleged, I mean, we don't know what the child has said because the court's not spoken to the child.
Okay, well, what I'm gonna do is appoint a guardian ad litem.
I was gonna ask if you would do
Appoint a
that.
guardian ad litem to interview the child. Now, people homeschool people all the time. And I've always had, during my years in the legislature, I always had a good relationship with homeschool groups. A lot of the best students I've ever seen and the most successful students at the next level have been homeschooled. So I don't have a natural prejudice against homeschool. But I am aware that because of that, when children get a certain age, and I still think there are restrictions in Kentucky for homeschool children to participate in extracurricular activities. Is that right? Can they do that now? I think there are restrictions.
It's a limited thing, and when you live at basically Black's Ferry, it's a little bit hard to get where you need to get.
And Judge, in response to that, we're assuming the child's not in activity. She is. She's doing gymnastic classes, has for over a year and a half.
I wasn't assuming anything. I was making a general observation of what I've seen in the past because I haven't heard any proof in this case. So who is next on the list as far as guardian ad litems? You got one? We'll take a look at the list and we'll appoint a guardian ad litem and we'll expedite this thing just because school's just now getting started. We'll have a hearing. We can have a hearing on it, take proof both ways, give everybody plenty of time on October the 2nd.
I know Mr. Burke and Mr. Brooken would like it expedited.
You'll be on vacation.
Mr. Brooks says he'll be out of pocket with his family on that date, Your Honor.
October 23rd.
They put it off a long time. I know. October 23rd, and I'll have Mr. Bertram get with you all.
Well, I'm gonna go ahead and point to guardian ad litem, and it depends on what the report to me says, whether I think it needs to be expedited quicker. After I see that report, if it's compelling enough, I might just call the attorneys involved and schedule a hearing before then. If not, it can wait till October the 23rd, since he's not available on October 2nd, okay?
Thank you, Judge.
Okay, thank you, Albert.
I'll be in touch.
Hicks versus Sarvella.
Judge, this was my motion, for leave to inspect a property,
Yeah, I saw
property,
that.
take some photographs. That's a boundary line dispute. Counsel for the opposing side reached out to me this morning. They're gonna be agreeable to it.
Okay.
We're gonna work out the details and we'll tender an agreed order if that's
Okay,
acceptable.
I would suggest that the order put time and place and.
We're gonna put all the details certain in there. Yes, sir.
Okay, no
Thank
problem, yeah. Mhm. Day versus Kirk. Day versus Kirk, modified, this was a pro se thing by Caleb Day, and doesn't appear we'll pass over. Pardon? Are you on this Day case?
I am, Judge. I represent Ms. Kirk.
I don't see Mr. Day here.
And Judge, I think this was just passed last month from his motion. And
Well,
so I just asked it to be taken off docket till he refiles something. Cause I don't
there's
think,
something else. Do I have something later on that he's filed also? Is there something later on in the docket?
I've not received notice of anything.
Well, I was gonna say that in this pro se document, it doesn't say, was it served on?
No,
you?
it was not
Yeah,
served on.
well, we'll just strike it for being, I'm gonna strike the motion for having it not complied with the rules of court.
Thank you,
If you'll
Judge.
submit an order to that effect. The next one, motion for contempt of court. That's what I was looking at. It's the same.
I think it's all in the same motion. I've not seen the motion. but
It
looking
doesn't
on the
appear to
motion.
have been served either, so we'll strike it also, okay? American Express Bank versus Julie Barton.
Yes, Judge. Julie Gordon here for American Express National Bank.
You want to turn your camera on?
But I'm having a hard time getting my camera to work today.
Yeah.
I mean, I can try to
No,
go back.
both parties are not here on here. You represent
American Express.
who, and Julie Barton is represented by all divided up.
Your Honor, this was a last minute.
Huff, is that correct?
I'm sorry.
James Lawson.
But James Lawson, the Lawson Law Firm out of Owensboro somewhere.
I'm not familiar with them. I'm just acting as local counsel. I was asked to come in. It was on for, I think for motion to dismiss for lack of prosecution.
Well. This was the arbitration, it was an arbitration case and the defendant, Julie Barton, suggested that she wanted arbitration, and then her attorney came back, and as I remember, and said that it wasn't the defendant's duty under the arbitration agreement that was in the loan document to initiate the arbitration, but it was up to American Express to do that. Now that's the whole case. in a nutshell. Zwicker and Associates represents the plaintiff, which would be American Express, and the defendant was represented by James Lawson of Lawson at Law in Shelbyville, and filed a response.
Okay, Judge, I just have here that it was on for a motion to dismiss for lack of prosecution. And it looks as though if arbitration has taken place, it looks like they're requesting that it be made eligible for a final order of garnishment on the return of positive interrogatories, but I'm not sure if arbitration, I'm not sure where the process is. Again, I'm just acting as local counsel and just wanted to make sure that, I think they just wanted to make sure that it wasn't dismissed.
You know, it's been a long time since a lot of people would probably, I should do it, go down through the docket and dismiss all the things that there hadn't been any action on, but I cannot imagine that there was an order from this court that was sent out to dismiss anything for lack of prosecution under the rule. Do you have a copy, counsel, of anything that this court has issued that we're gonna dismiss the case for lack of prosecution?
You know, I do not, and normally I will get those. It may have been just, an abundance of caution. They asked me to show up today, but they didn't provide me.
Pass over it. Evidently, the defendant is not concerned about it, or something's going on. So y'all can redocket this thing. It will not, I'll make a notation that nothing was done to affect the status of this case being still on docket. You can electronically submit an order to that effect if you want to. Okay?
Yes, Your Honor. Thank you very much.
Okay. Michael Hirsch and Jessica Herschel, I guess, versus James Whitlow and Karen Anderson, third party. Okay, Ms. Capps, I see this motion. There's not a motion, but there was an order previously entered here that called for this matter for custody to be reviewed today. And the petitioner, Michael Hirsch, was given 10 days to obtain counsel. Is he here today?
I've not seen him, Judge. He's not contacted my office, and I've not had an attorney contact me on his behalf. And it's my understanding that he has some cases pending in other counties that he's been evading service on.
Criminal or civil or?
Civil, he's got another child that he does not have contact with. They've
Okay,
been
the third
attending
party
some-
respondents in this case, before we spend too much time disparaging the third party respondents are here today. And what is their relationship to the child involved?
They are the maternal grandparents.
And the mother is here too.
That's correct, Judge.
Maternal grandparents. And the last time we were up here, he appeared without counsel.
Yes.
And I gave him 10 days to have counsel and schedule this today in an order that was distributed to him at a Hardyville address.
That's correct.
Okay, and we don't have any entry of appearance at this time of him or any evidence that he followed a court order to get an attorney. So I'll just keep this temporary order in place. Unless you want to file.
Well, Judge, at this time, I would like to make an oral motion about the child's contact with him, because as we were here previously, he had not had contact with this child in well over a year. The court granted him some temporary visitation. He gave us an address. I've been contacted by the lady that lives at that address. She's the mother of his other child. He's not lived there in over 3 years.
I'm not comfortable without some kind of written motion, but I will say this, that I would accept an order that says that came to review this matter today. He had not complied with a court order to obtain counsel and make it appear for review, and until he does so, the visitation rights shall be suspended.
Right, Judge.
So that's not a permanent order. It just opens the door till he makes an appearance and redocks. Okay?
All right, thank you.
Okay, thank you very much. Riverview Ag Credit versus Lisa Faye Brandon.
Afternoon, Judge.
Hello.
Morgan Wiggins for River Valley. And this was our motion to set for trial. Since filing this, I believe Mr. Hurt and I have come to an agreement that we're going to depose Ms. Branham on the 30th of September. I'm happy to redocket this for October 23rd if the court prefers.
If we can schedule through the court, I'm agreeable to setting a trial date once they're finished with the depositions. I don't have an objection
Well,
to
it might
that.
be resolved.
I'm hopeful. I will do my best.
So it won't be you can, let's schedule a status conference on October the 23rd, okay?
Okay, thank you,
That
Judge.
date has not been resolved. We can, and you can decide whether you want a bench trial or a jury trial, and we can set one in short order, okay?
Thank you.
Okay, thank y'all very much. Carmen versus Warner.
Your Honor, I'm Travis Bell. I'm appearing on behalf of Mr. Carmen via Zoom.
Who are you, sir?
I'm Roderick Carmen, sir.
Okay, and you're Jessica Warner?
Yes, Your Honor.
Okay.
Your Honor, the court will probably recall that we previously filed a motion.
I'm looking at the order right now. Give me just a second. Okay, ma'am, you have appeared today pursuant to the court order previously, and you were to give reasons, and you have a right to have counsel, but why don't you have an attorney here today?
I simply cannot afford one. I
Okay,
wish I
well,
could.
I'll let you be sworn then. If you'll raise your right hand, you swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth. You can lower your hand now. You were to appear here today. There's been an allegation that you have failed to provide parenting time to the petitioner for the minor child EC. Could you explain to me why you have not done that?
Yes, Your Honor. So there are two children, Elizabeth and Gabriel.
I don't want you to call their names. You can call
Okay.
them by their initials, okay?
Okay. So GC, I did take for his visitation on the scheduled day and time, but EC has absolutely refused.
How old is EC?
She will be 16 in October. She is very adamant about not going, and honestly, I did not feel that it was my place to have to physically force her.
Okay, I'm going to appoint a guardian ad litem to interview EC. Counsel, that seemed Mr. Bell, does that seem appropriate to you?
Yeah, I think that's a reasonable request, Your Honor.
Okay, I'm going to do that, and you shall leave the address where this guardian ad litem can contact your child to interview the child. Quite frankly, Mr. Carmen, it's difficult sometimes to force a 16-year-old child to do anything. So what we'll do is we'll get an independent attorney to interview the child, have some private time, make recommendations to the court, and see if there can be some sort of thing. And you're the biological father of the child?
Yes, sir.
I find that even when children are at this age and when they've been damaged by things that have happened in relationships like that, ultimately a problem will develop later in life for them if we don't try to resolve those issues now. So, I mean, it might be a fortuitous turn for your daughter's future that we do this. So we'll appoint somebody. If you'll step down to the clerk's office, give them an address and a phone number where the guardian ad litem can contact you, okay?
Yes, Your Honor. A quick question.
Yes.
Would the guardian ad litem also be representing my son?
No, this
Just-
person, they
Okay,
won't represent you. Now, I would suggest there is not legal aid generally available here. Have you talked to Appalachian Research and Defense Fund? Have you contacted them?
oh, no, I'm sorry. I mean, my son. Would both children be able to
Well,
talk to the guardian ad
That
litem?
issue is not involved with me. The son does not refuse to visit it. He's visiting, that's fine. I mean, the guardian ad litem might interview you, might interview the son, might interview other people, but they will not be representing the son. They're specifically to look at the interest of EC because that's the only issue in front of them, okay?
Yes, Your Honor.
Okay, thank y'all very much.
Thank you.
Capital One, successor to Discover Bank versus Julie Barton.
Good afternoon, Judge William Rich on behalf of the plaintiff. This is our motion to stay the case pending arbitration. I think this may perhaps have been the same defendant that was in an earlier case with American Express that's represented by Mr. Lawson in Shelbyville. And he's not opposing this motion. We've had no response.
What about the other case too? Is arbitration on the other case going on also? Are there two different cases?
Two different cases, Your Honor, and that was, I think that you said that you referenced Zwicker and Associates. They do not represent the plaintiff in this case. That's a different case.
Okay, thank you very much.
There should be an order tender, Judge.
Okay, thank you. Thank you so much.
Thank you.
Caps versus Caps.
Yes, Judge, this is our motion for a default divorce on behalf of Ms. Capps.
You want to buy, is there any property involved or children involved?
There's no property involved. There is a minor child involved.
Okay, so you're asking to be bifurcated and have a decree entered?
Well, Judge, he has not taken his family and transition class. He has not reached out. He's not hired any counsel. He was served on July
Okay, well,
16th.
what I'm telling you is that I'm willing to enter a default judgment and to put in there that enter a judgment as far as custody. You're saying that you don't want joint custody, she wants custody, and that he should not have any visitation until he does his joint class, and he'll have 30 days to put this back on the docket and request a hearing concerning child support or custody, okay?
Okay.
I guess it should be a little bit more October 2nd than appear October 2nd if he has any objections. Okay? I don't like to go ahead and do any permanent orders concerning that because there's might be something that we don't know or that sort of thing.
Yes, sir.
There no property to be divided or anything?
No, sir.
Okay, if you'll submit an order, we'll take a look at it, all right?
Thank you, Judge.
Yeah, no problem. Dakota Lee Vanderpool versus Brianna Marie Vanderpool. Oh, okay. Okay, let's give me a little update on this, Ms. Capps.
Judge, one thing,
As middle of the road as you're capable of, give me.
I don't know if I'm capable of that, Judge. One thing I do need to address is we've submitted a proposed temporary order based on the court's ruling the last time we were here back in July. Ms. Perigin and myself have tried to do an agreed order, but we can't seem to come to an agreement. So there's an order that's been submitted just per what your ruling was on the temporary timeshare. And it's,
I'm just like, I didn't enter that, so let's just like start all over again.
okay. Well, Ms. Perigin's client has been getting every other
Okay, well,
week.
give me a factual situation here. These two people, are they married?
These two people are
Okay,
married.
These two married, and they were living together in a house that was owned by his mother, right?
They were living with his mother in his mother's residence.
Living in a house together that was owned by his mother.
That's correct.
And they have one child?
Two.
Two children, okay. Now, I looked at some of these sort of things. There was a motion filed last time, and that he wanted her to move out of the house. Correct?
Judge, I think she vacated it through her own volition. But we were asking for exclusive
I
use of the
thought
marital
that she was
residence.
told that she had to leave, that an officer told her that she had to leave, is what the pleading said. Isn't that right?
I think that may be what they're alleging,
No,
but
I'm not saying it happened, I'm asking you what
Judge,
happened.
that is her version of events, yes.
Is it that an officer came and told her she had to leave and that he had temporary custody?
Is that what?
yes.
Okay. Okay, now, in the hope, what can y'all not agree to?
Judge, we've discussed trying to do mediation. I'd even spoken with Miss Murphy's court mediator so that I could save expense on the parties. I don't know that we can come to.
Okay, you alleged and I read the pleadings and the response, you alleged that she has some paramours that are related to her work at the chicken plant.
That's correct, Judge.
And that one of them is a registered sex offender.
Yes,
She denies having any relationship with either one of them. Okay, so there, so it shouldn't be, if she denies having any relationship with either one of them, it should not be difficult to have an order, when we enter an order that says that she shall not have those children around either one of them in contact in any way. If she does not, if she has previously had a relationship, she's not being candid, then that will solve that problem also. Okay, now, where is your client living?
Judge, she is located down in the Housing Authority, correct, here in Burkesville.
She's got a place down there.
Yes.
Does she have furniture in it and that sort of thing?
Yes.
Okay, now, taking the two paramours and the sex offender out of the thing, what are you going to use to there was also
there's some allegations.
allegation that she made some comments to someone about postpartum depression.
That, as well as text messages I have that she's communicated to my client about concerns with her sister, who has been living in her previous residence with her and who is
What kind
around.
of concern?
Well, she sent statements that her sister had threatened to kill her, was going to beat her up.
We addressed
There's-
this last time, Judge.
Well, I'm wanting to hear it again. Okay, so.
And then
Wait just a second. Where is the sister?
The sister is currently over in Monroe County.
but the sister comes with her to all the
Wait just a
visitation
second. Wait just a
exchanges.
second. Where is the sister?
The sister is over in Monroe County, Kentucky.
Okay, you have any objection to prohibiting the sister from coming around her or the children in her house until this is over on a temporary
Well, the
basis?
sister has been coming around during the temporary agreement we have in place whenever she was formerly living with her mother and her sister. And I don't think that there's been any issues. Is that correct?
Well, there's
Okay.
concern here. I'm talking about a temporary order. I'm not talking about adjudication permanently of that sort of thing. Until we get this thing resolved, it has a concern here that there's been some threats made by the sister. So until we get it resolved, I'd like that included in an order that the sister stay away, okay, and away from the children in harm's way. Now, what other concern do you have?
Then the other issue is transportation because she does not have a license and she's depending on her family living in Monroe County to provide transportation while she's residing here in
Now,
Cumberland.
what are you doing for transportation to get to work and that sort of thing?
I do ride with my mother who lives in Monroe County. Sometimes I do
You
call.
need to speak up.
I'm sorry. I do rely on my mother for transportation who lives in Monroe County.
Hey,
I apologize, sir.
okay, go ahead.
I also sometimes call coworkers, a coworker of mine, her name's Elena. She lives here in Burkesville.
So you catch rides to the chicken plant?
Yes,
Well, what about you? So if you live here in the city, your children, are either one of the kids, there's two children, are they involved in school yet?
Not yet. They're 4 and 2.
4 and 2, okay, not in preschool, little Panthers, anything. Who keeps the children while you're at work?
currently their dad, Dakota.
We've been trying to work on a childcare arrangement with Mr. Vanderpool since the last hearing we were at. And I don't think he has been very forthcoming with
Okay,
providing any
now,
information.
both of y'all have a tendency to take a whack at each other that I noticed. I don't want you whacking right now. I'm trying to see where the common points are, okay? See if we're getting there. So don't take a whack at what you think he has or hadn't done. That doesn't help things, okay? Ditto? Okay. So is your client working anywhere now?
Judge, he's does some odd jobs with his grandfather. And then he's also talked to Rick that runs the gas station down here to where he can work around the schedule to work whenever he doesn't have the children.
People are standing in line to get people to work around here. Getting a job is not a difficult thing. Okay, now give me some other, now that we resolved these three issues about those three individuals, give me some other reason why there should be limitation on her visitation.
Like I said, Judge, just concerned about statements she's made about hurting herself or taking the children and not bringing them back and leaving the state. That's another concern.
Okay.
Judge, I think with no valid driver's license, it's a moot point to say that she's gonna try to leave the state.
But it's easy to leave a state without a driver's license, you know.
I understand. I don't think she.
Here's the thing about it. There's nothing I can do. She's gonna get the children sometime. There's nothing I can do to keep her from snatching these kids and taking off, or from your client from leaving. There's no order that I can do that. So what I want you to do, hey ma'am, I'm gonna tell you the same thing I told your husband. When I'm talking, you be quiet, okay? I don't want to be hard on him, but I haven't had the best day today. So I don't need, even a minor irritation is not appreciated, okay? So here's where we are. I want y'all to go back in the room back there and get me as close to 50-50 as you can get me, with the protections that will give this young man some assurance that these people are not around his children, whether or not the allegation is true. I'm going to, for this purpose, presume that those protections ought to take place until we make a further finding on that, okay? Now, you need to take in consideration for your client the limitation she has. Why don't you have a driver's license?
I'm from California.
They don't have driver's license in California?
I don't have a driver's license because I really never needed it before coming out here.
Yeah.
I
Well,
understand that
are you studying to get a driver's license now?
I have, and I would have already had it. But my documents, like my birth certificate and my social security card were lost in the displacement.
Okay, all right, well, as long as you're working toward that, but I do want to make sure that since she's barring rides and anything, that the agreement includes that anybody that those children ride with have the proper booster seats and restraints in there. I'm sure you have booster seats and restraints.
Yes,
You can take them around. So I want that included in there.
And also a valid driver's license, Judge.
If she's not to be driving.
Okay.
Whoever has it has to have a valid driver's license and insurance and all the other things that you have. I don't presume that she would put her children in a car with anybody that didn't have a valid driver's license or what, reputable, that sort of thing. Cause most of the transportation seems to be done by her. So y'all, I'm gonna ask y'all when I finish it, if either one of you got anything else on the docket?
I do, Judge.
Okay, as soon as that's over, y'all go back there and try to work me something out. Okay, now Davis versus Pitcock. Okay, Davis versus Pitcock. Okay, Jessica Pitcock comes and moves the court to dismiss the above style action on the ground that there's some kind of juvenile action going on in district court. Why should that affect this action?
Judge, we believe it is my position that according to this statute, the KRS 430 or 403-270, that anytime after a legal proceeding has been commenced by a parent seeking to regain custody of the child, we don't determine that time period for the de facto
You're
statute.
saying that it tolls
Yes, Judge, that is our
What's
position.
your response to that?
We filed a written response, Your Honor, with regard to that. So over the course of the last 2 years, I believe that's the total position.
When did you file a written response?
I did.
When?
Would have been yesterday.
Well, see, it doesn't really work very well for me.
When the motion was filed on Friday, Judge, so I
That
mean, we
doesn't
scurried
work very
around
well
and
for
tried.
me. That doesn't work very well for me either, so.
But
So we're probably not gonna rule on it today because it was filed late. And it's not within the rules and your response was like, so I'm, you know.
Yeah, I'll try to get it out as quick as I can, Judge.
understand, but I'm gonna listen to what you have to say. Just tell me briefly what your response was as far as the statute is concerned.
I will, Judge. The statute says that within 2 years preceding, I guess, whatever determination of this court, is kind of nebulous. That the parent, that the proposed de facto custodians have had the child reside with them for an aggregate period of 1 year or more if the children are over the age of 3, and these children are. And so there is a tolling provision that states that, as it was articulated, but there's not been any proceeding that was filed by the respondent until April the 30th of this year, Judge. There was a motion made in the juvenile court action for a return of custody. But prior to that, there had been 15 months at least,
So
because
you're saying you don't need this toll period?
that's correct, Judge. I mean, the tolling is
Yeah,
moot.
even if you accepted the toll, you think that you qualified in a number of
And-
months that you had to pay.
And we're
Is that what you're
conceding,
saying?
yeah, we're conceding that there would have been some kind of petition filed in April of this year.
What do you have to say about that?
Judge, our position is that their time period is not accurate. We've got affidavits along with, we have time dates.
Okay, it
and
sounds like
pictures.
we're gonna need to take some proof
Yes.
on this. Won't you, I don't wanna do it on a regular rule day. Why don't y'all get your calendars? You got your calendars here right now?
I do, Judge.
Okay. Megan, if you're listening, why don't you bring your calendar and come out here if you're still here. I'm gonna look at this. She might be gone. You step back there and see if she's back there.
You said if you had a language, she's listening.
Okay.
She called the girl.
Okay. On the 8th, August the 8th, I have some hearings scheduled on the O'Donnell case, but I don't think that will take all day.
September the 8th, Judge, is that what you're?
Yes.
Judge, I will not be available on that day. I'm out and won't be available.
You out of the country or gone somewhere, or you just got something else that day?
I've got something else that day, and also would have been unable to rearrange that schedule.
Well, I was just gonna see how long it was gonna take. I could accommodate you in time.
It would be a full day.
Okay. See, I don't do full day things.
I wish I didn't either, Judge.
Yeah, okay. We have a civil case that's scheduled. Shrine versus Spears, isn't that correct? It's set for a jury trial. And then I have a custody case on that's a 2-day trial. I have a custody case for the next day scheduled. Do y'all have that on your schedule? What case is that? What does that involve? Lengthy thing?
Upstairs and downstairs.
Okay.
That's not good.
What does the 10th look like to you?
The 10th, Judge, that morning I will be in Russell Circuit Court. It's a regular motion hour. But that afternoon I'll be available.
Okay, let's do something that afternoon. Let's set it at like 2 o'clock. That'll get you time.
My apologies, Judge. I was looking at the wrong date. But I will be available that afternoon. It's in Pulaski County rather than Wilson County.
10.
Yes.
Well, that gives you extra hour to pick up.
That's right.
You're operating fast time. So let's schedule a hearing on this. And now, before we leave here, let's agree what we're down to here. Okay. That was on, what day was it, the 10th?
It's a motion for visitation.
Yeah. I don't know, I cannot get this to. There you go. Okay, well, I have to have two hearings scheduled that afternoon, but we can work both of them in if the other one starts at 2 also.
I'm scheduled for 10.
The other hearing for 10.
Spring Prairie visitation.
Yeah, so that'll work out well. The other trial shouldn't last that long. If it does, we'll just make it 10 o'clock at 1 and make y'all at 2. Now let's talk about the issues that we're talking about. Number one, you're challenging whether they have de facto status or not. So we'll have to have a hearing on that.
Yes.
Okay. Then if they do have de facto status, I guess at some juncture, we'll have a hearing on who should have custody.
That's correct, Judge.
Yeah.
And we would be prepared to go ahead and go
Well,
forward.
let's do both of those. And if I decide they do not have de facto status, then we'll have the hearing on the custody situation and child support or any of those other things we have there. And then we'll make that a final judgment. And then whichever side doesn't win, that will make it right to appeal, I think.
Okay. If I Judge, I was just making sure that we would have witnesses available during that, for that time. Because if we're gonna have a full blown hearing, I would imagine we would need
Yeah,
to have
let's
some.
say as long, I've got a rule day the next day, I think, over in Clinton County, so I'm on the 11th, so I have plenty of time on the 9 and the 10.
Judge, and it's been a while since I practiced a custody or domestic case in front of you, Judge. Previously it was Mr. Psalm, and now I know that you're taking the docket on yourself, but pre-hearing statements, those kinds of things, are you wanting any
I'm
of
not
those?
real big on those,
Okay.
Witness and exhibit list.
Yeah. Y'all exchange a witness list within 5 days today, okay?
Okay.
And then 5 days from today, give a witness, let's make it 6 days, since it's Thursday, I'll give you midweek next week a witness list. What kind of exhibits do you want?
Judge, at this point, we may be submitting some text messages, reports from the cabinet stating Ms. Pitcock's progress in the juvenile action.
Well, I would suggest you have people from the cabinet here to testify rather than just a report from there. So, and if you have text messages and things like that, we can get them in and you make sure that you can, that you can introduce them, that you have, lay a foundation on them, okay? I don't know with AI what we're gonna do about text messages and things in the future, you know? We'll see, maybe we're not advanced enough yet to do that. Is there anything else to be decided?
No, Judge.
Okay, thank y'all very much.
Thank you.
Judge.
Okay, we got the DVO docket. DVO docket,
That DVO was set to expire.
pardon?
That DVO was set to expire on 30.
Okay, is there anyone here on the DVO docket? Will we be back here again before it expires?
No, it expires on 30. Saturday.
Well, I guess it's gonna expire, and it showed up.
Your Honor, I will try to slip in a motion to withdraw in a case and set it for this afternoon on Cole versus Gray. It's an indivisibility case, and my clients and I are just not, they know a lot more about it than I do. So
Where is the case? What's the status?
Mr. Little has a motion for contempt set for, what day is it, Tracy?
October 2nd.
October 2nd. I would suggest if we could give them 15 days to get new counsel. There's an issue over the survey and equal division. This is the case you said we'd just go ahead and divide it into 2 tracts of equal value. They seem to think it was supposed to be 2 tracts of equal size. That wasn't what was planned ever. So they know more than me. So I'd like to get an order entered to get out of it.
Who's the attorney on the other side?
Very little.
Well, just submit me an order and give them 30 days to get out.
There's a,
Well, just submit it electronically or whatever, okay?
thank you.
Drop it. We got it.
All have other issues.
Okay. Make sure I enter that 30 days. Okay, at 2:30, I will call. Laurel Circuit Court will come to session at 2:30, so let's go off the record and get the Zoom in.
He filed a motion for yesterday, and I told Megan she's ready to put it on the second.
Jeez. Okay, we're not gonna go until 6 minutes from now, so I'll take a quick break. You need to see.